Good morning, everybody. Happy Wednesday. Welcome to TCF Live. My name is Dan Soul. I will be your guide through our 3-hour journey through Courtlandia. This morning, we will start in Allegan County, Michigan. This is Judge Gosellis.
On charges of criminal sexual conduct in the first degree and criminal sexual conduct in the second degree. Counsel, if you had an opportunity to review this felony complaint with Mr. Lewis, if so, will he waive the formal reading for purposes of arraignment only?
We will be waiving formal reading, Your Honor.
Mr. Lewis, both of these charges are felony charges, and in district court, you are entitled to a preliminary examination on felony charges. As required, we are going to set that for you within 2 weeks. Your probable cause conference is a week from tomorrow, May 14th. That will be at 1 p.m. in District Courtroom D. Preliminary examination itself is the following Wednesday, May 20th at 9 a.m. in this courtroom, District Courtroom A. Bail will set at warrant authorization at $10,000, cash or surety. Court file shows you posted a $10,000 surety bond. Bail will be continued in that amount at this time. Will also indicate you've already retained your own attorney in this case. Court staff will mail to you and to Mr. Lynch, the attorney of record, the dates and times that I just mentioned. But again, your next court appearance is a week from tomorrow at 1 o'clock in the afternoon. Okay?
Thank you, Your Honor.
Thank you.
Mr. Badger, were you all set? Yeah. Mr. Badger, are you still there?
Yes, I am. Sorry about that.
This is file 220426FY and file 220261ST, both on Kenneth Lawson Bailey. The first is based on a felony complaint issued by the Allegan County Prosecutor's Office, and this is on a charge of possession of methamphetamine. They also indicate Mr. Bailey has a prior drug conviction and is a second habitual felon. File 220261ST is based on a citation issued by the Gun Lake Tribal Police on a charge of driving while license was suspended. There was also a no proof of insurance, which already has gone to default judgment. Mr. Badger, please.
Thank you, Your Honor. Sam Badger appearing on behalf of Mr. Bailey for the limited purpose of arraignment. We have reviewed the charging documents and would waive their formal reading. He does not qualify for a court-appointed attorney, as he has indicated that he will be retaining his own attorney. I did send 2 amended sheets because I accidentally selected that he does qualify for a court-appointed attorney on the first 2 that I sent. But Mr. Bailey does want to retain his own attorney in this. And so we would request that these matters be set for a probable cause conference and a preliminary examination, Your Honor. Thank you.
I still have the original.
I just got them.
Okay. File 220426FY, the charge of possession of methamphetamine. This is a felony charge, and in district court, you are entitled to a preliminary examination on a felony charge. As required, we are going to set this for you within 2 weeks. Your probable cause conference is a week from tomorrow, May 14th, and that will be at 1 p.m. in District Courtroom D. Preliminary examination itself is the following Wednesday, May 20th at 9 a.m. in this courtroom, District Courtroom A. Bail will set at warrant authorization at $1,000 personal recognizance. Bail will be continued in that amount with the condition you not possess or consume any alcohol, marijuana, or illegal controlled substances while the case is pending. Court staff is going to mail directly to you the dates and times that I just mentioned. If you do hire a lawyer, be sure to forward the date and time on to your attorney. But again, you're looking at a week from tomorrow, so you need to hire an attorney as soon as possible on that case. On file 220261ST, the charge of driving while your license was suspended and not having any proof the vehicle you were driving suspended was insured. will enter a not guilty plea, set this for a jury trial, indicate you're going to hire your own attorney in this case. In this case, bail was set at $300 personal recognizance. Bail will be continued in that amount. Condition of bail is that you not drive until you obtain a valid operator's license to do so from the Michigan Secretary of State's office. This case will be set first for pretrial conference with the prosecutor's office and then for jury trial in this courtroom, District Courtroom A. Again, court staff will mail to you the date and time of your next court appearance. Be sure to forward that on to your attorney. So with that, you are all set on both of these cases today. Again, you're due back in court on the felony case a week from tomorrow at 1 o'clock in the afternoon. Okay?
Okay.
File 242068 SM, People versus Tara Lynn Duelling. Here this morning for arraignment, charged through a felony complaint issued by the Allegan County Prosecutor's Office and a charge of child abuse in the 4th degree. Mr. Badger, please.
Thank you, Your Honor. Sam Badger appearing on behalf of Miss Duelling for the limited purpose of arraignment. We have reviewed the charging document and waive its formal reading. She's entering a plea of not guilty and does qualify for a court-appointed attorney. We request that this matter be set for a pretrial and a jury trial, Your Honor. Thank you.
When are not guilty, please set this for a jury trial. Indicate you're requesting an attorney at public expense. Court file shows you released from the Allegan County Jail on a $500 personal recognizance bond. Bail will be continued in that amount at this time. Case to be set first for pretrial conference with the prosecutor's office and then for a jury trial in this courtroom, District Courtroom A. The public defender's office has determined you are indigent and will be appointing an attorney for you at public expense. So an attorney from the public defender's office will discuss your case with you at your pretrial conference. The date and time of that pretrial conference will be sent to you with a clerk's office in the mail. So you are free to hang out from the court proceeding this morning. Be looking for your next court appearance date in the mail. Okay. I have 3 files on Silas, Everett, Newcomb. All 3 of these are based on the same citation issued by the Allegan County Sheriff's Department on charges of driving an uninsured motor vehicle, driving while his license was suspended, and having expired plates on the motor vehicle. Mr. Badger, please.
Thank you, Your Honor. Sam Badger appearing on behalf of Mr. Newcomb for the limited purpose of arraignment. We have reviewed the charging document and waive its formal reading. He is entering pleas of not guilty and does qualify for a court-appointed attorney. He will also be denying the civil infraction at this time as well, Your Honor. And we request that these matters be set for a pretrial and a jury trial. Thank you.
And file 261067 SM, the charge of driving an uninsured motor vehicle. Will enter not guilty plea. Set this for a jury trial. Indicate you're requesting an attorney at public expense. We'll set bail on this file at $1,000 personal recognizance. Condition of bail is that you not drive this 2009 Ford until you obtain valid operator's insurance on that vehicle as required by Michigan law. This case will be set first for pretrial conference with the prosecutor's office and then for jury trial in this courtroom, District Courtroom A. Public defender's office has determined you are indigent and will be appointing an attorney for you at public expense. On the charge of driving while your license was suspended, will enter not guilty plea. Set this for a jury trial. Indicate again you're requesting an attorney at public expense. We'll set bail at $500 personal recognizance. Condition of bail is that you not drive until you obtain a valid license to do so from the Michigan Secretary of State's office. That case will be set first for a pretrial conference with the prosecutor's office and then for a jury trial, also in this courtroom, District Courtroom A. Again, the public defender's office has determined you are indigent, and they will be appointing an attorney for you at public expense. On file 26SD4389CSI, the charge of having expired plates on that motor vehicle. It's a civil infraction. The public defender's office will not be representing you, but I will enter a denial on that, which will generate a notice for a pretrial conference on that as well. And you'll be discussing that case privately with the prosecuting attorney's office. If it's not resolved, that case will be set for a formal hearing in this courtroom, District Courtroom A. So with that, you are free to hang up from the court proceeding this morning. Court staff is going to mail you the dates and times of your pretrial conferences on all three of those cases. We're looking for those in the mail, okay?
Hey.
File 261059 SM, People versus Paul Richard Towne, here this morning for arraignment charged through a citation issued by the Allegheny County Sheriff's Department on a charge of operating an uninsured motor vehicle. Mr. Badger, please.
Thank you, Your Honor. Sam Badger appearing on behalf of Mr. Towne for the limited purpose of arraignment. We have reviewed the charging document and would waive its formal reading. He is entering a plea of not guilty, and he does qualify for a court-appointed attorney. And so we request that this matter be set for a pretrial and a jury trial, Your Honor. Thank you.
Learn not guilty, please set this for a jury trial. Indicate you're requesting an attorney at public expense. We'll set bail on this at $1,000 personal recognizance. Condition of bail is that you not operate this 2016 Dodge until you obtain insurance on that vehicle. Case will be set first for pretrial conference with the prosecutor's office and then for a jury trial in this courtroom, District Courtroom A. Public defender's office has determined you are indigent, and they will be appointing an attorney for you at public expense. So an attorney from the public defender's office will discuss your case with you at the date and time of your pretrial conference. With that, you are free to hang up the court proceeding this morning. Be looking for the next court appearance date in the mail. Okay?
Thank you, sir.
Thank you. Kelly, give me a moment on this one because I do want to check. See if there's any. This seems like he's been before.
Well, he takes a moment. Good morning once again, everybody. TCF Live on a Wednesday. My name is Dan. It is good to have you here with me this morning just to address something that was talked about in the chat with regards to sidebar last night. So some technical difficulties caused us to have to cancel. But whenever there's a change in programming, I always put something in the community tab. We do that here on TCF, and we do it over at In the Blind as well. So if you can't find a show, go to the homepage for the channel on YouTube and look in the community tab, and you'll find a post there if there was some kind of change. Just an FYI.
Present.
This is Bruce Harvey, the family of Camps.
Okay, I'll take that as a yes. This is file 242510SM and file 242509ST. Both charges were issued through a citation issued by the Michigan State Police on a charge of driving an uninsured motor vehicle and driving while his license was suspended for a incident date going back to June 19th of 2024 near the Gun Lake Casino. Mr. Camps was present in court back on the 13th of April. At that time was informed that fingerprints needed to be taken before we could proceed to an arraignment. An order for fingerprints was generated on April 13th, and the clerk's office adjourned this out again until today. As of today, I still do not have fingerprints on file, and without fingerprints on file, I'm unable to proceed to an arraignment. Are you physically here in the building right now, sir?
I am not in the building, no. I have no way of getting there, and Even if I got there, I have no identification papers.
Okay.
No,
Well,
no license.
a show cause is going to be issued for your failure to comply with the order for fingerprints. If you fail to appear for the show cause, a bench warrant will be issued for your arrest. And then the sheriff's department would transport you down here, and then you would be fingerprinted. So I don't think either one of us want to have that happen. So again, make arrangements to be fingerprinted because a show cause is going to be issued for your failure to comply with the order for fingerprints that goes back to April of this year. You are all set today. I'm unable to arraign you on these two files because of the lack of fingerprints. So make arrangements with the Allegheny County Sheriff's Department, either at the jail or here at the courthouse, to be fingerprinted sometime between now and the show cause hearing. The show cause hearing will be in person. You are all set today, sir, and hopefully we'll get these on file soon. Thank you.
I have some dental cares.
I was gonna say we didn't have it. That's why.
All right, that's the end of his day. Let's stay in Michigan, but let's go to Otsego County, where justice is best served in a converted pole barn. And this is Judge Mertz.
Mr. Papp, are you able to hear me okay?
Yeah, can you hear me?
I can, yes, thank you.
Can I ask you a couple questions before we get this started?
Yep, let me just call your case real quick and then certainly do that.
Thank you.
We're on the record now in People versus Carl Papp. This is file number 256857. The record should reflect Mr. Papp is appearing today by video from Department of Corrections. If I could have counsel put your appearances on.
Morning, Your Honor. For the record, Michael on behalf of the people.
Thank you, Your Honor. Richard Truesbury on behalf of the Papp.
Okay, thank you. So we're here for a sentencing issue that the court was made aware of by Department of Corrections. But before we get to that, Mr. Papp, you indicated there was something you wanted to say.
Yeah, I was just curious, a couple questions if you could answer for me, because I've been trying to get this answered this year long, but this is actually over a year this has been going on. Truce is yet to give me a very definitive answer. The other, the district court kind of said something, but I want to make sure, is a preliminary and evidentiary hearing the same thing?
No, I mean, they
I
are
didn't
sort
think
of.
so.
A preliminary hearing is an evidentiary hearing, but there's all kinds of evidentiary type hearings. Preliminary hearing is a type of evidentiary hearing.
What about is it the same thing as a probable cause conference?
You know, now we're getting into the area where I'm not just defining things. I'm giving you advice.
Because the only reason, I don't mean to cut you off, John. The only reason I'm asking is because I never had a proper cause. And I've told Richard this from the get-go. I never had a proper cause. I had an evidentiary hearing. I never had a proper cause. They scheduled it before he was my attorney, but I never went to it, which I kept telling him there's a violation of my due process. But the second thing is, I just got back from the law library before I had this meeting, so I wanted to make sure I don't sound stupid when I'm talking to you. That I'm just curious, and my appellate attorney told me to ask, how is it that they retain a warrant when myself and the so-called victim said this never happened, even testified in front of the district court, I didn't do this, and yet they still went and got a warrant off of a third-party hearsay, which in the Michigan court law states you cannot grant or get a warrant off of hearsay. They have to have proper, like, identifying evidence. If it's the victim saying, I did this, which we had an affidavit signed. I don't know if Richard ever turned it into the courts, where Lauren said, I never did this. And then my last thing is, I was never told about a tether until like a month ago from the Department of Corrections. Because I would have never accepted this plea. I would have made sure that they took that off there. Because that hinders my job. Because a person might be like, hey, why you have that? I'm not hiring you. Because as you probably noted in my PSI, I run my own business. And I'm going to continue to do that when I get out. But if a person sees like this thing, they're like, whoa, oh, you're an alcoholic, maybe, because they maybe think it's alcoholic monitor system or something. They're going to assume that I'm a problem and not want to hire me within it before it hinders my livelihood to support me and my family.
Okay.
Because I was
Alright.
never told this legit, but this whole time, no one ever told me if that's a possibility you could get this. So I'm asking the courts if they would, as the thing I got from the MDOC is to amend it where it is, because that was never brought to me, which I feel that should have been something Richard due diligence, like, hey, you know, by accepting this is also a possibility they might not make you, but they can make you. He's never informed me of that in any way, shape, or form through this whole process.
Okay.
This is pretty much accept this plea. This is the best thing you're going to get. If pretty much not, I'm going to spend the rest of my life here. I was like, well, I want to be out one day to see my son.
Okay,
But that was never
so
a part of it. Go ahead.
just let me know when you're done, because every
I'm
time
done.
I start
Sorry, I'm
talking, you start talking again. So I want you to say whatever you want to say, but just let me know once you're done so that I can answer your
I'm done.
questions.
Go ahead, Your Honor.
Okay. All right, so the things you raised about the probable cause conference, the warrant, those are both issues that you can raise on appeal. That's not something that's before me to make a decision on today. But those are grounds that your appellate attorney, I'm assuming, you know, you guys will talk about that, and those are things that can be raised on appeal. With regard to the lifetime electronic monitoring, they're two separate issues that we're raising here on that today. You're raising the argument that you weren't aware that that was something that was going to be a consequence of your sentence. That argument also is something for appeal, to tell the Court of Appeals, you should vacate my plea because I wasn't properly advised of this consequence. And the Court of Appeals will decide that. So that is also an issue for appeal. Why I set this hearing is by statute, based on your conviction, I have to impose that. And that was something as an oversight or a clerical error that the court failed to do at sentencing. But the fact that I'm required by statute to impose it is a different issue than whether you were properly advised of the consequence of that, and that you might have not entered your plea if you had known about that. That's an appellate issue. Do you see the difference between those two things?
Yes, Your Honor. So my next question is, what happens so if I move out of Michigan, because like Tennessee, where I'm thinking about moving to, doesn't require me to do that? Because this is, from what I'm saying, this is just a Michigan law. It's not a countrywide law. It's a Michigan state law. So if I move out of Michigan, technically that does not abide to me, if I'm not mistaken, right?
I do not know. That's something that the parole board would address with you when you're released on parole.
And then my next thing was, because I know this is part of your court, from what it looks like, I'm about to beat my gun charges. It looks very good on that right now. Would I get re-scored, not just my time back for that about year, which you already agreed to I would, but would I get re-scored because after doing my guidelines, it drops it down like another 2 years on top of that?
Yeah, again, that would be an issue for your appellate attorneys to advise you on. That's, you know, I have no idea what effect it might or might not have. And sitting here today, there's no way for me to know that.
All right.
But that's something that your appellate attorneys would give you legal advice on, the effect of having any conviction vacated, what that would mean for subsequent convictions.
Well, they told me it'd be up to you because it technically, as like you already agreed, it would go back. If I do beat the gun charges, I'm going back in front of you to get resentenced on this very case to knock that, give me my year back. And then on top of that, if I'm just asking for the record, would you allow me to get re-scored on top of that then? Because by being because they told me if you take off my 2 gun charges in the 4th degree habitual, it's going to drop my time down. Even if you, again, like how you did touch my max guidelines, it's going to knock it down another 2 to 2.5 years.
Yeah,
Which
so
therefore,
that very well may end up back in this court if all of that happens. And if it does, then I'll have briefing from your attorney and from the prosecutor. I'll have a report from the Department of Corrections. And you're right. I mean, ultimately, I might have to make a decision on that. But sitting here today without any of that information and without knowing whether or not that's even going to happen, I can't give you an idea of what I might or might not do a year from now, having all of that information that now I don't have any of that. So I can't tell you what I might or might not do or what the law may or may not allow. So.
Thank you. I just wanted to get some stuff for the record. So when my appellate attorney gets to look at this, because we've both been just dumbfounded by how this whole thing has went down and just how things legit happen, especially when the victim says this never happened and yet I'm forced to take a plea or get 30 years.
Well, I mean, you got her pregnant, so something happened.
But she but even then, we asked, like, well, not in your courtroom, in district court, how Hubbard went about this, because what they didn't tell you, there's been 3 tests, and which is weird. 2 of them came back not mine. One of them all of a sudden did on the very last one that Hubbard brought from Newberry down to wherever the state lab is, which is kind of weird in itself.
All right.
But
Well,
it is
either
what it
way,
is.
we're not going to relitigate your case here this
Yeah.
morning. That's something that you can address all of those things on appeal. What we're here for this morning is, again, the error by the court in not imposing lifetime electronic monitoring at the time of sentencing, which the court was required to do. I did review the transcript from the sentencing hearing, and the court did not articulate that for the record. Mr. Rolla, on behalf of the people, do you take any position on this?
Pursuant to the holdings in People versus King, that's Michigan Court of Appeals 297, Michigan 465, 824 Northwest 2nd, 258. It's a 2012 case, and People versus Comer by our Michigan Supreme Court 500-278, 901 Northwest 2nd, 553, a 2017 case. They specifically affirm what the Department of Corrections indicated, that for this particular offense, it is mandatory lifetime sentence.
Mr. Trush.
Your Honor, to the extent that Mr. Papp has not already preserved his objection to it by his statements, for his benefit, I would indicate he does object to it. Obviously, he's raised an objection on the basis of not being aware of that as a potential consequence. Additionally, when I communicated with him prior to this hearing, he had raised an objection to me based on it. But effectively, I touched on this when he spoke, but I don't think he articulated it the same way, being a limitation on his ability to basically travel between states. So again, to the extent that he hasn't already preserved those with his statements, I would specifically object on those bases.
Okay, so those objections are all preserved for the record. From my standpoint, based on the conviction in and of itself, the statute does require the court to impose lifetime electronic monitoring. So subject to the objections and appeals, the court will impose that at this time. So we'll have an amended judgment of sentence that will reflect that. Mr. Rolla, is there anything further today?
Not in this case. Thank you, Judge.
Mr. Trush.
No, thank you, Your Honor.
Mr. Papp, we're going to go ahead and disconnect at this time. Thank you.
All right, thank you.
Gather round, my felonious children, for question and answer time with Judge Mertz, where felons from around the Michigan DOC will ask questions that should be asked of a lawyer. Oh, look, here's another contestant. Let's see what questions he has.
All right, we have People versus Jones. This is file number 266961. The record should reflect Mr. Jones is present today by video from Otsego County Jail. If I could have counsel put your appearance.
That's the record. I call on behalf of the people.
Thank you, Your Honor. Richard Trush, on behalf of Mr. Jones. Your Honor, we're here today and we do have an amended plea offer for the court, which would contemplate a plea to counts 1 and count 2 with a dismissal of the habitual offender notices. I spoke to Mr. Jones prior to court today. This offer is brand new. I mean, probably 20 minutes ago was made. Mr. Jones has another matter that's presently set, I think, for a district court hearing. I think it's next week. I'll kind of put it to Mr. Jones, but I think based on the new offer, I think we'll likely accept it. But I suspect that we want to get both of them up here to be able to do it. But again, I want to put it to Mr. Jones because it's slightly different than what we had talked about.
Did you want to address him directly?
Oh, sorry.
I don't want to get in between you and Brian on that.
So Mr. Jones, did you hear what I indicated about the offer?
Yes, I heard.
Okay. That offer is consistent with what we talked about, but do you want to delay it 30 days to get the other matter up here, or do you want to make a decision on that offer today?
The delay is good.
So I'd ask the court to set it 30 days out so that we can get the other case up here. And frankly, I'd likely would be my advice to him in any event, just because, again, it is slightly different. And I want to make sure he understands what he's doing before he does anything.
Okay, Mr. Rolla, do you have any objection to that?
I do not, Judge, as the plea offer involves both files. The original offer included the habitual second. The amended offer allows the withdrawal of the habitual second, but a plea to the case that has not yet been bound up to circuit court.
Okay. So we'll set this for a status conference plea hearing in 30 days. I will indicate for the order that the new case should be assigned to me and set for hearing on the same date as this file. So we'll have both of them heard in June. Mr. Jones, did you have any questions about how we're going to proceed with your case?
No, sir.
Roll anything else in this file?
Thank you.
Mr. True.
Nothing further on this one.
All right, thank you, Mr. Jones. We're going to disconnect at this time.
Alrighty, once again, friends, good morning. TCF Live, good to have you here. Let's go down to Florida. Judge Mercer.
Mr. Ricardo, good morning. How are you, sir?
Good morning, Your Honor. I'm doing well. How are you?
I'm good, thank you. Would you please introduce yourself to Mr. Trejo, make sure he can see and hear you?
Señor Trejo, yo soy Jordani Ricardo, intérprete para que se pueda comunicar con el juez. ¿Usted me ve y me escucha?
Sí, lo veo, lo escucho.
He can hear me and see me, Your Honor.
Perfect. Mr. Trejo, you're here because you've been accused of driving with no valid driver's license?
Señor Trejo está aquí porque se le ha acusado de manejar sin licencia de conducir válida.
You also have a detainer from the United States Immigration Service.
También tiene una orden de retención de parte del Servicio de Inmigración de Estados Unidos.
I'm going to appoint the public defender's office to represent you and ask that you listen to Mr. McDaniel, your attorney.
Le voy a asignar la oficina del abogado de oficio para que lo represente y le pido que escuche a su abogado, el señor McDaniel.
Okay. Your Honor, I spoke to Mr. Trejo. He's going to plea of no contest to the charge as listed.
Su señoría, hablé con el señor Trejo y él se va a declarar no me opongo ante los cargos.
Understanding he'll serve 2 days in the county jail, credit for 2 days, $400 fine, adjudication withheld.
Entendiendo que se le va a condenar a 2 días en la cárcel con crédito por los 2 días que ya ha cumplido, una multa de $400 y se le pudiera suspender el fallo de culpabilidad, el Estado responde no objeción.
Waived his right to a jury trial and call witnesses and understands that any plea can be used against him in immigration court.
Él ha renunciado a su derecho a un juicio, a llamar a testigos y entiende que cualquier tipo de acuerdo en un caso penal le puede afectar en el Tribunal de Inmigración.
Understands that ICE has a hold on him and they'll pick him up within 48 hours.
Él entiende que Inmigración tiene una orden de retención para él y que lo recogerán en un plazo de 48 horas.
Also understands that the $400 fine is a civil judgment against his credit rating.
y él entiende que la multa de $400 es un fallo civil que le afecta su crédito.
And Mr. Mitchell, is that agreeable with the state?
It is, Your Honor.
Señor Mitchell, ¿está de acuerdo el Estado? Lo está su señoría.
Mr. Trejo, did you hear that agreement?
Señor Trejo, ¿escuchó
Yes, sir.
usted ese acuerdo?
Sí, señor.
Yes, sir.
Do you have any questions about that agreement?
¿Tiene alguna pregunta acerca del acuerdo?
Sí, nomás único que si se cuenta desde el día que me arrestaron las 48 horas.
Yes, my question is, do the 48 hours start counting since I was arrested?
No, the 48 hours don't start until they're notified that they can pick you up, which will happen after first appearance if you enter this plea.
No, las 48 horas no comienzan hasta que se les notifique a ellos que lo pueden recoger. Eso se hará después de esta comparecencia inicial, si es que usted acepta el acuerdo.
The reason for that is right now, they don't have the right to pick you up because you have local charges.
La razón es que en este momento ellos no tienen el derecho a recogerlo porque usted tiene cargos locales.
But once you either post bond or are released on your local charges, that's when they can be notified to pick you up, and that's when it starts.
Pero una vez que usted pague la fianza o ya quede libre de los cargos locales, ahí es que se les notifica que lo pueden venir a buscar y ahí es que comienzan las 48 horas.
Do you have any other questions?
¿Tiene alguna otra pregunta?
No.
No.
Is this the plea you would like to enter?
¿Es este el acuerdo que desea aceptar?
Sí.
Yes.
Mr. Trejo, I'm going to accept your plea of no contest to the charge of driving with no valid driver's license.
Señor Trejo, acepto su declaración de no me opongo ante el cargo de manejar sin licencia de conducir válida.
I'm going to withhold adjudication of guilt and sentence you to 2 days in jail, give you credit for 2 days you've already served.
Le suspendo el fallo de culpabilidad y lo condeno a 2 días en la cárcel, pero le doy crédito por los 2 días que ya ha cumplido.
I'm going to also impose the court costs and fines of $400.
También le impongo las multas y costas del tribunal por $400.
That amount will be reduced to a civil judgment.
Esa cantidad se reduce a un fallo civil.
And this sentence is based upon the criminal history I've received, which shows no prior criminal history.
Y esta sentencia se basa en sus antecedentes penales que me mostraron, que muestra que usted no tiene antecedentes penales.
But given the immigration hold, probation is not practical.
Pero debido a que tiene la orden de retención de parte de inmigración, libertad vigilada no sería práctica.
Immigration will be notified immediately after first appearance to pick you up.
A inmigración se le notificará justo después de la comparecencia inicial para que lo venga a recoger.
Do you have any questions?
¿Tiene alguna pregunta?
No, ninguna pregunta.
No, no questions.
Have a good day, sir.
Que tenga buen día, señor.
Thank you, Senor Ricardo.
My pleasure, Your Honor. Thank you.
We do have a couple people, Mr. McDaniel, that have friends or family in the courtroom. The first one on the docket that does is Eric Ferguson. Mr. Ferguson, good morning. Mr. Ferguson, your wife is in the courtroom. You're here because you've been accused of one count of driving while licensed, suspended or revoked, third offense. There is probable cause for that charge. I'm not convinced it's a felony charge as the officer has it checked, but that's a call for the state attorney's office to make. Your third offense used to be a felony, and several years ago, Florida law changed, and now it's only a felony if the prior suspension is based upon certain non-financial issues. So looking at your driving record, it looks to me like you may not qualify for a felony, but we'll let the state attorney's office make that determination. I intend to treat it as a misdemeanor for bond purposes this morning because I don't think it qualifies for a felony based on the driving record I looked at. The officer doesn't mention that element at all. Mr. McDaniel, anything on behalf of Mr. Ferguson? No, Your Honor. Mr. Mitchell?
I was going to say that, Your Honor. It all kind of stems on what that 2025 suspension may have resulted and what may have come from it, but we'll figure that out, and we are okay with you treating this as a misdemeanor bond.
All right, so given, Mr. Ferguson, given your numerous prior charges of the same type, now some of them are older ones, your bond's gonna be $2,500 cash or surety. You have the right to go through a bondsman, or you have the right to put up all $2,500. You have a condition not to drive a motor vehicle unless you get a license. Get a license, get your license straightened out, you drive all you want, but if you get caught driving without a license, that will violate your bond. Your wife's in the courtroom. Let me see if she has any questions. Any questions, ma'am?
I am aware that his license was only suspended due to a speeding ticket he received and it was taken in full.
No, he's got multiple suspensions, just so you'll be aware. I don't know what he's told you or what you've been led to believe. He has 4 or 5 suspensions. Would you like to know what they're for?
18 years. I looked at the DMV that they said, okay, I cleared everything on him and all he had to do was reinstate.
When was this? When did you look at it?
About a month ago.
Okay.
I paid everything up for Greenville, Tennessee, and here. He had 2 separate speeding tickets. I paid both of them. And they said he was cleared as far as reinstating his license. I just had to pay the reinstatement to Tennessee because that was where it was suspended at. And he wasn't aware at the time. We thought it was just a ticket that had to be paid because there was no court date to it.
His-
we were just late getting the money.
His driving record shows a unpaid fine from 2023 in Florida. Some type of suspension is still active in Tennessee. Another insurance issue in Tennessee and a driving while revoked. No, that last one's fixed. So it shows 3 different current suspensions. So it could be that you've got to pay a reinstatement fee on all 3. I don't know.
Where they would run them concurrent, but it's 3 separate. They would allow me to pay the reinstatement and then he would be able to make his license here.
So if you get his license, he can drive all he wants. He got caught the same charge in 2025 and he's not got his license reinstated. You look surprised. Well, let me clarify. The offense date was December of 22. He resolved it February of 25 in Jackson County. Driving license suspended. But since then, he still hasn't gotten it fixed and he's continuing to drive allegedly. Okay.
He has a full-time job. We live less than a mile from here. He is established here. He has done really well as far as not, I didn't know if he was suspended or not but as far as anything else goes, he has been doing really well in the past 10 years that I've been here.
Okay. All right, well, thank you for coming. So, Mr. Ferguson, as soon as you pay that, you certainly can drive all you want, but don't be driving until you get it straightened out. As soon as that bond's posted, you'll be released. The jail will give you a notice for your court date. Technically, it's charged as a felony right now. We're going to give you a notice for your felony court date. That'll be June 2nd. June 2nd at 8:30. You need to check with the clerk's office before you come to court that day to make sure it does get filed as a felony, because if Mr. Mitchell's office looks at it and they think it should be a misdemeanor, that will change your court date. They'll transfer it to misdemeanor court. Right now, the officer's accused you of a felony. I've just chosen to set a misdemeanor bond for the reasons I've already said. Sir, do you have any questions?
Great.
Have a good day, sir. So, ma'am, as soon as the bond's posted, he'll be released, okay? Yes, ma'am. Yes, ma'am, absolutely. The next person that has friends or family here on the list is Joseph Sims. Mr. Sims, good morning. Mr. Sims, you're here for first appearance. You've been accused of 7 charges. Mr. Sims, you've been accused of trafficking in cannabis, in possession of a variety of illegal substances. They are THC oil with intent to distribute, THC wax with intent to distribute, plant-based marijuana with intent to distribute, THC extract wax with intent to distribute, THC, another THC oil with intent to distribute, and possession drug paraphernalia. So 7 total charges you've been accused of. I'm going to listen to the attorneys and then we're going to go from there. Mr. McDaniel, anything on behalf of Mr. Sims?
Your Honor, just that he's local and, he's got strong ties to the community and he's not going to be going anywhere.
All right. Thank you, Mr. Mitchell. Anything?
Your Honor, given the trafficking charge that was filed in this case, the state has filed a Nebia motion to prove the source of the funds. If he were to bond out in this case, Don't know if you want to go ahead and hear on that motion today or save it for another time. I was informed by Mr. McDaniel that I believe he has his friends or family that are willing to post the bond. I have no objection to that. I'm just following what is protocol for our office and filing the motion for Nebbia in this situation. Regardless of whatever bond he's given, we just request that he be subject to random UAs. And if you want to go forward on the Nebbia motion, we can today.
He has a prior possession of
Yes.
marijuana with intent to distribute, or
Yeah, in Leon County case number 192203 CF.
do you know how that resolved? Was it a misadjudication withheld?
Yeah, adjudication of guilt was withheld.
Do you know if he was placed on any probation or anything?
That one I didn't look at.
Yeah,
It looks like he was.
The disposition doesn't tell me.
3 years probation.
So he's no longer on probation, Mr. McDaniel?
No, he's no longer on probation.
Okay. All right. So Mr. Sims, I'm going to set you a bond. The trafficking is going to be my normal trafficking bond. I said in every trafficking virtually, I don't know if I've ever said anything different. That's $50,000. The other cases, they're kind of duplicative, and I don't know if the state will choose to file them separately or not. They may. It gets complicated when you have the same base chemical substance, but in different forms. Whether or not they can charge you separately, it gets pretty complicated. I think they can charge you. I don't know if they can sentence you separately. So what I'm going to do is I'm going to set you a $2,500 bond on each of these other cases. I'm taking into account the bond on the trafficking is so high because it's a trafficking. Trafficking is a first degree felony, which carries a minimum mandatory imprisonment. What that means is if you're convicted, you haven't been, but if you're convicted, there's a minimum mandatory imprisonment. I don't know if I told you, but you have close to 10 people in the courtroom on your behalf. So you have one bond of $50,000. You have 1, 2, 3, 4, 5, 6 bonds of $2,500 each. That should be 15,000. So 50 plus 15 is 65,000. Your total bond is $65,000 cash or surety with a condition of random urinalysis. So what that random urinalysis condition means is that if you post the bond, you will have a condition that you can be drug tested at any time at the direction of a judge. And if you fail the drug test, you will go to jail with no bond. That's what a random urinalysis means. Now, two things. Number one is I'm going to ask the jail give you a notice for your court date. The notice for the court date will be June 2nd at 8:30. They'll give you that notice before you leave the jail. That'll be your next court date. The second thing is the state has filed a Nebbia motion. A Nebbia motion is a federal case. The Nebbia case is, but Florida has a similar state statute that basically says the judge can, if requested, and even if not requested, the judge can look at the source of proceeds before allowing a bond to be posted to make sure that those funds don't come from illegal arenas, to make sure they're not come from illegal drug sales in this case, because allegedly you admitted to the officers having the substances for sale. So they're saying we want to make sure that the money used to post bond doesn't come from an illegal source. So Mr. McDaniel, are you wanting me to go ahead and inquire in that today with these family members? Is that your plan? So we can go ahead and address that issue or what?
Yeah, I'll just go ahead and ask them. I think one of them or some of the family members may be paying it. And I'll also ask what they would consider a cash bond if they are going to be paying it. And he has local strong ties, and that way the money could go towards some other use besides just that. I'm not sure which family member wants to talk about who's going to post a bond or.
First, we need to find out what's the state's position on a cash bond in this case.
Yeah, that's different for this one. I mean, I have no objection to a cash bond.
Okay, so you have no objection to the normal 10% that they would normally pay a bondsman, them giving that to the clerk of court.
Yes.
So that would be $7,000.
$6,500.
$6,500. Okay. So generally, when a Nebbia motion is filed, I'm talking to the family, so don't give family, Mr. Sims. When a Nebbia motion is filed, the person's just held with no bond until they can get in front of Judge Garcia. Okay. But I've never had a case where there's a Nebbia motion filed and family was here wanting to post bond. So I have no problem going ahead and hearing from the family about the source of the bond funds if someone wants to come up and testify to that. Mr. Donifro, come on up, please. And I saw in the complaint on the cover sheet his parents. So based on his parents, I'm assuming this is your grandson, correct?
It's my nephew.
Nephew, I apologize. I got it wrong relationship. So it's nephew. Mr. Donifro, what I'm gonna do is place you under oath and ask you about the source of the funds if you intend to post bond. Do you solemnly swear or affirm the testimony about to give in this case to be the truth, the whole truth, and nothing but truth to help you God?
Sure.
Do you intend, or does your family intend to post bond for your nephew? You can put your hand down.
Yes.
And where would be the source of the funds?
Personal.
Can you assure me that none of the funds would come from him?
Yes.
Mr. Mitchell, any questions for Mr. Donifro?
No, Your Honor, I'm familiar with Mr. Donifro and Mr. Donifro's family. So as long as the funds are coming from him and not from Mr. Sims, that is fine with me.
Mr. McDaniel, any questions for Mr. Donifro?
No, Your Honor.
Thank you for being here, Mr. Donifro. So I'm going to find that based upon Mr. Donifro's testimony that Mr. Sims, you have the right to post the bond. The funds are not going to come from you. They're going to come from your family. And that's what the rule requires. It's just for the reasons I've already said. So it's a $6,500 cash bond. Now, let me explain this. There are benefits to a cash bond. The reason Mr. McDaniel asked for a cash bond is this. If you pay a bondsman that $6,500, the money's spent. It's gone. You don't get it back. That's for the bondsman's services. That's what they're vouching for your appearance for. That's how a bond works. But with a cash bond, you pay the same amount, $6,500, but it's paid to the clerk of court. The clerk of court holds that $6,500. If there are court costs and fines imposed later on by state law, that money must go towards court costs and fines. On the other hand, if the case is dismissed, that money is returned to whoever posted it. That's not true for a regular surety bond. That is true for a cash bond. I only do cash bonds if the state and defense agree, like they have in this case. So it's a $6,500 cash bond. It's posted at the jail. As soon as that bond is posted, he'll be released. Just need to do what you can to make sure he stays off of anything. If he is on anything illegal, because if he gets drug tested by myself or Judge Garcia and he tests positive for marijuana and or anything that he doesn't have a valid prescription for, he will go to jail with no bond and that $6,500 may be forfeited. Question. Yes, ma'am.
Of course, he does have a card, a legal card or whatever, but of course it stays in your system for quite a while. If he was tested a week from now, it's still gonna be in the system. What does he have to protect himself there?
It gets really complicated with marijuana because the amount of marijuana in your system depends upon the type of substance you take in. So if you take it in a lawful substance in compliance with a physician's orders, theoretically, it should result in a certain amount of THC in your system. On the other hand, if you're taking THC illegally, which may have a stronger concentration or may be in an amount of THC, number of usages that exceed the physician's allotment, then theoretically the THC content may be higher. It gets very complicated. My suggestion is comply with his physician's orders, and that's it. In substance as well as quantity. Okay. Any other questions from the family? Mr. Sims, do you have any questions?
Yes, sir.
No questions? All right. And I don't know why I thought of grandson. He's not, based on his age, there's no way that could be Mr. Donifro's grandson. I was just way off with that. Mr. Sims, I wish you the best. As soon as the family posts bond, you'll be released. Thank you to the family for coming.
Just let the family know that, I mean, if he doesn't show up for, I have every indication he will show up for every court hearing, but if he doesn't show up for court, y'all could lose that $6,500. So make sure he's in the courtroom the dates he's supposed to be. All right.
Thank you.
Good luck to you.
All right, next case.
All right, we're going to continue to ride with Judge Mercer, but programming alert, do not go anywhere, because as soon as we're done with Judge Mercer, we are going to go up to Judge McNally and Horderman. So don't go anywhere.
Other young ladies coming, mother and sister, auntie and sister. Okay, sister and auntie, I apologize. Sister and auntie are in the courtroom. Mr. Hitchens, you're here because you've been accused of possession of more than 20 grams of marijuana. I have read the complaint in your case. There is probable cause for the charge. Mr. Hitchens, a couple things stand out about your situation. According to the packet I've got from the jail, you have no prior criminal history. Is that accurate? Never been arrested anywhere, correct? Is that a yes?
Correct. That's correct.
Correct.
And the other thing is that you've had the same job for 25 years at UPS. Yes. Is that right? Okay, that's great. Let me hear from the attorneys then, see if they have anything else I need to be aware of. Then we're going to address your bond or your release status. Mr. McDaniel?
No, that's your honor.
Mr. Mitchell?
Similar conditions, just he'd be subject to random UAs.
Mr. Hitchens, what I'm going to do is let you pick between a bond and a conditional release because your criminal history as well as you have much different charges than the last case. If you want to post the bond, that is a third-degree felony. Your bond's going to be $5,000. If you want to accept a conditional release, I am going to offer you a conditional release because of your employment and criminal history. Either way, you will have a condition of random urinalysis, and you will also be given a court date in just a moment. Do you have any questions about the choice between the bond and the conditional release, Mr. Hitris?
He probably asked for a cash bond if the court's with him.
Mr. Mitchell?
I got no objection to that.
All right, so cash bond in that case would be $500 cash only. So you have a $500 cash only bond. Mr. Hitris, when that bond is posted, you'll be released. The jail will give you a notice for your court date, which should be June 2nd at 8:30. And you've got the condition of random urinalysis, which I've already mentioned. Let me see if your family has any questions. If the family has any questions. So as soon as the $500 cash is posted at the jail, he'll be released immediately. Okay. Mr. Hitris, do you have any questions?
No.
All right. All right. Get back to work and you'll see Judge Garcia on that court date. Okay. I think that's it for friends or family for first appearances. Mr. McDaniel, so we can go back to Willie Fant. Mr. Fant, come on up. Mr. Fant, good morning. You're here because you've been accused of 1 count of possession of methamphetamine and 1 count of possession of drug paraphernalia. Mr. Fant, there is probable cause for those 2 charges in the sworn complaint. I've looked at your criminal history. It appears you've been to prison 3 times, which probably makes it unlikely I would give you a conditional release, but I think you're entitled to a bond as far as I can tell. Let me listen to the attorneys and I'll address your bond status. Mr. McDaniel, anything?
We just asked for a bond and asked to take into consideration the strength of the case and go from there.
Okay, thank you. This is a case where there was allegedly a substance under him in the seat of a car that was operated by someone else. He supposedly was in the passenger seat. Mr. McDaniel?
Correct. And it was a very small amount also, I believe, but yes, Your Honor, that's correct.
Okay. Thank you. Mr. Mitchell, anything?
Nothing as to the bond. We just request that he be subject to random UAs also.
Thank you, Mr. Fant. Your bond's going to be $5,000 on the felony charge. The paraphernalia was packaging. On those, I typically said $1,000. It's not like a pipe. It's not a separate device. It's simply the packaging the felony substance was allegedly inside of. So you've got a $5,000 bond on the felony, a $1,000 bond on the misdemeanor, $6,000 total. Cash or surety, you can go through a bondsman if you wish. You do have a condition of random urinalysis, and the jail will give you a notice for your court date, which should be June the 2nd at 8:30. Mr. McDaniel, anything else?
Nothing else, Your Honor.
And Mr. Fan, any questions?
No, sir.
Wish you the best, sir.
Barbara, thank you for the $5 super chat earlier, and thank you as well for just gifting 5 memberships. Very much appreciate that.
Just a second, Ms. Hill. Let me get my notes caught up here. All right, Ms. Hill, you're here because you've been accused of 1 count of driving under the influence and 1 count of child neglect. Ms. Hill, there is probable cause for the charges. Ma'am, I've also looked at your criminal history. I saw a prior child abuse from a couple of years ago that was dismissed and a few other charges that I see on your criminal history. But as far as I can tell, you're entitled to a bond, ma'am. Let me see if the attorneys have any additional information before I address that bond situation. Mr. McDaniel, anything?
Your Honor, she has local ties, obviously, and, her kids, and she also works at the Super 8 motel there here in town. We just asked for possibly a cash bond.
Mr. Mitchell?
As for the cash bond, we'll leave that up to the discretion of the court. I mean, it's a weird situation with this case, but nonetheless, we request that she have the condition of no possession or consumption of alcohol. I know the complaint makes, accusations that she appeared to be under the influence of alcohol, even though she denied it. But we request the court take into account her BAC, which was 0.12, may show circumstantial evidence of alcohol involved. And given the fact that there were children involved, while she was in actual physical control, allegedly in actual physical control of the vehicle.
So is the state opposed to the cash bond, or you're not opposed?
Given that she's had a child abuse arrest in the past, I would be in opposition to a cash bond.
Okay. So Ms. Hill, your bond's going to be $2,500 on the DUI, ma'am, $5,000 on the child abuse. Child neglect. There is evidence to support the charge, at least in the complaint. That doesn't mean you'll be convicted. You may not be, but they certainly got enough evidence to charge you as set forth in this complaint. It's $7,500 cash or surety. I'm not going to set a cash bond because the state's opposed to that. I think that rule pretty much prohibits me from doing it if they're opposed to it. You can go through a bondsman if you can't post all the money, ma'am. You do have a condition not to possess or consume alcoholic beverages as part of the bond. And you also have a condition. Was there another requested condition you had? Was that the only one?
We would also request random UAs just in since there may be circumstantial evidence, she may have had something else in her system.
What was the evidence of anything other than alcohol? I don't remember that.
I think if I remember, staggered, dilated pupils, staggered speech, maybe.
It was just I don't think there's any evidence of anything that alcohol wouldn't cause and doesn't cause in almost every DUI case we see. But I do have a concern about the request. What's the state's position on contact with this particular child?
Oh, yeah. We would just request no unsupervised contact.
With the child that's the subject of this case?
Yes. With the
Mr. McDaniel, would you like to be heard on that?
And I'm the only one that's.
Judge, she's a single mother. She's got multiple kids, and one of the youngest child that's in this action here, she goes to Kitty Campus, the daycare school. I would think it'd be extreme hardship on the family to try to, I understand the court's concerns, and I understand the state's concerns, but I think it'd be an extreme, very hardship for a single mother with multiple kids to try to find someone to take care of the youngest child or have no contact or to.
I'm the only one that takes care of it.
So we just asked the court to kind of take that into consideration.
So Ms. Hill, the allegation is you had a .12, the child was unrestrained sitting in a booster seat and you were chasing another vehicle that had your older child in it. There's no way I'm going to let you have unsupervised contact with that minor, that small child. I think that'd be foolish of me to do that. So you've got a condition of no unsupervised contact with that child, and you've got a condition that you not drive that child, even with someone supervising it. I don't want that child riding with you unless it's approved by a judge first. You forfeited that right by having this charge with that breath alcohol and the allegations that have been alleged against you. So you can have contact with your child as long as it's supervised, but even if it's supervised, you can't be the driver with that child in the vehicle. And I'm only referring to the small child, I think maybe around 3 years old, that was in the car allegedly with you. I'm not referring to the older teenager that was in the car in front of you. That the older child was the alleged victim in the prior child abuse. The younger child is the alleged victim in the new child neglect. Ms. Hill, do you have any questions, ma'am? Actually, let me give you a court date. That'll be
the second,
June 2nd at 8:30. They'll give you that notice in just a second, and you'll get to use the phone in just a second, ma'am, to try to post the bond. Ms. Hill, do you have any questions?
Yes, sir. Is there a way I can get conditional release today?
No,
I don't
no. Go ahead. Go ahead, ma'am.
I'm the only person that's taking care of Ava. Her father passed away, and I've been the only person taking care of her. I'm a single parent. I work very hard. I have a house. I have cars. Is there any way that you could please let me out today? I work very hard for a living.
Yeah.
I'm the only one that takes.
What your criminal history shows is a 2009 battery in Washington County. Now, sometimes I don't have dispositions. I've got a battery on a law enforcement officer in 2012. We've got a disorderly intoxication in 2013. Battery on a firefighter. That may be the same charge. Could be the same charge. That can be the same charge. Sometimes they're duplicative. Resisting an officer with violence in 2012. You've got a probation violation in 2013. And I've already mentioned the child abuse that was dismissed within the last couple of years. 2015 of resisting an officer without violence. No, ma'am, you're not a conditional release candidate with that criminal history. And there's certainly evidence that you're not, at least yesterday, there's evidence you were not doing a very good job of taking care of this child. So for those reasons, I would not give you a conditional release, but you've got the bond that I've set. Do you have any other questions, ma'am?
No, sir.
Have a good day, ma'am. We have Jaden Kennedy. Mr. Kennedy, good morning. Mr. Kennedy, Mr. McDaniel added you on the docket today, I believe, to try to resolve your case. So listen to your attorney that I've appointed to represent you.
Your Honor, I spoke to Mr. Kennedy in 26239 MM. He's going to plead of no contest to the charges listed. You understand that he'll be sentenced to 60 days in jail, 2 days jail credit, $370 fine, adjudicated guilty. He has waived his right to a jury trial and call witnesses. This will resolve this case today.
And
trustee doing.
Mr. McDaniel, excuse me, Mr. Mitchell, is that agreeable with the state?
It is, Your Honor.
Mr. Kennedy, did you hear that agreement?
Yes, sir.
Mr. Kennedy, do you have any questions about that agreement?
No, sir.
Is that the plea you would like to enter to resolve this case, sir?
Yes, sir.
Mr. Kennedy, I'm going to accept your plea of no contest to the charge of trespass in case 26-239 MM. A judge you guilty, sir, sentence you to 60 days in jail, give you credit for 2 days you've already served, impose court costs and fines of $370. That will be a civil judgment if you don't get it worked off, but hopefully you're going to get those court costs and fines worked off through the trustee program. If you don't pay them, that is. So, Mr. Kennedy, I know that you inquired about the trustee program yesterday. Talk to the jail staff about that after first appearance, and they can explain to you how the program works if you have any more questions. But hopefully you'll get in that program and you'll get you quite a bit of gain time. There's no probation involved in this sentence. This is what's known as a straight jail sentence. When you finish the jail sentence, this is all behind you. Any questions, sir?
Is there a projected release date without? I already told you. Nothing else, Sean. Thank you.
Wish you the best, Mr. Kennedy. All right, so that concludes our first appearances for today. We do have a few.
Alrighty, friends, hour one of TCF Live on a Wednesday already in the books. Time flies. Okie dokie. Let's go up to Michigan, Judge McNally and Hoarder Man.
Robert Thomas Boyd, 25B 82557. Morning, Mr. Boyd. How are you?
Morning, sir. How are you?
Good.
Good too.
Your name? Your name?
Robert Thomas Boyd.
All right. Everybody's name over here.
Bob Harrison, behalf of Brown Seven, let me show.
I'm Foley Carter on behalf of Johnstown Township. You did allow to speak to an attorney this morning, so Ms. Patillo is representing you.
Okay, I was going to tell you you have the right to a lawyer. So Ms. Patillo will be representing you. Is that what we're going to do?
Yes, sir.
Okay, good. All right, so I just sent her in to take care of one with the county. So it's going to be a little bit, okay, Mr. Boyd?
Coming now.
Okay.
Judge, I have some updated photos.
Yeah, I got a packet. Is this the ones you're talking about?
It's all
Why don't you just hand those up if you would?
for taking yes.
Thank you. Good morning, Ms. Patillo. Your name?
Yeah, it's the open 82378 on behalf of Mr. Boyd.
So I hope Mr. Boyd and you had a chance to talk at length because if you need more time, I will. This has been in an ongoing blight condition. It's been in existence here for 25 years and I've sent him to jail once, I believe, maybe twice.
Go ahead.
because he's just not following directions. Now, I told him on, the last time he was in court, which was on March the 25th, I said he was to serve 90 days, credit 10. And that jail start date is to occur today. So technically, he's supposed to go to jail today for 80 days. You have no idea the history behind this. I've done everything I can. So, what would you like to tell me?
So, Your Honor, it's my understanding that Mr. Boyd, chose to represent himself through this matter. I don't think that would be very, idea. But I will say this, it doesn't sound like he ever had a viable plan in place to get this stuff removed. It sounds like he just tried to maybe do it by himself. He did get some offers from other agencies to help. I called.
Which he declined.
I'm sorry.
Which he declined.
Right. Well, while we were speaking, I called Veterans Junk Removal Service and I spoke to Everett. Their pricing is $150 to $1,000. We set an appointment for Eric to come out tomorrow morning between 9 and 10 o'clock to assess the situation and to give him a quote. They can also haul stuff away in trucks, and it's a veteran service. So he's not a veteran. Mr. Boyd is not a veteran, but the individuals who work for the company are veterans. So they work off of donations. So I'm assuming the cost wouldn't be very high. So Mr. Boyd was on board. We set the appointment. They're coming out in the morning. I understand that this case has been going on since April 2025, and then obviously years before that. But even with the 80 days in jail, the neighbors are going to have to sit there and look at this stuff. So.
Well, they could reissue another citation.
Right. So
And I've been trying to explain that to Mr. Boyd for the longest time.
Yeah, but I don't think he really had a plan. He does have somebody at church that's gonna come out every Sunday and Wednesday. So I think if he can get the bulk of that stuff removed by this Veterans Junk Removal Service, that may make it less work for the people from church, to remove stuff. I would ask if the court would at least let him get through this appointment, maybe give him a week or two, come back and see if anything's been done. Because Eric, I don't think it would take them that long. Once it's assessed, he gets a quote, they can start removing stuff.
No, does he have the money to do that?
He does.
It's spending the money I saved for my burial. Spending that.
So it's not that he wouldn't have the money, it's just that the money source that he has, obviously, he wouldn't necessarily use that. But at this point, 80 days in jail is. So I know that I'm just on this case, I know there's probably been several chances given. I would just ask one last.
You have no idea.
Yeah.
You have no idea. You have no idea how many chances I've given him. You have no idea. I begged him. You think I wanted to send this man to jail? I think you know me better than that.
We'll get one last chance.
What do you guys have to say?
Now, I'll start with the good news. Mr. Boyd did obtain a demolition permit. The garage is torn down.
That is good news.
Hasn't gotten the inspection to ensure that it was done properly or safely, but I understand that he's gonna get that done. Unfortunately, the remainder of the order is not complied with. So the trailer's full of junk, the boat, the inoperable vehicles, the piles of junk, debris, wood are still holding up.
I had on my wood stove back at the beginning of winter. In the middle of winter, I had over 10 face points. The guy dumped it on the yard out of his truck. I've been using it, and I've been working on this stuff here to get it done. So the wood's still there, but it's just a pile of wood.
I see it.
And I've got a young man that lives behind me who's going to stack it for me in my yard. Because I use wood to heat. And it's a half gone now already. So, Won't take long to get to what's left stat.
Okay, but you got all these vehicles here still too.
Well, he said that the vehicles are licensed and insured. I know the tire is flat.
Oh, yeah.
And the aqua is not parked on an approved, surface. So they do need to be aqua and parked on the approved surface.
Yeah, it's been flat since the time that we started this.
Well, it's been going down, so
Why are you paying, you're telling me you're paying insurance on all these, how many vehicles you have on there?
3,
You're paying insurance on all those vehicles that are just sitting there?
yeah,
Why?
because I drive junkers and if one breaks down, I have to get into another one to go to work. I work,
Well, I'm not suggesting you should operate a motor vehicle without insurance. Please don't take me wrong, but it just doesn't look like they've moved.
they move. I put air in the one and it'll move.
Well, you
I got a new
you can't just put air in a flat tire, sir. You have to get the tire fixed or buy a new tire,
Yeah.
right?
You put air back in, they all leak.
Wow.
You know, they're not new cars, they're all the tires and anything I have leaks. Part of life.
Judge, I don't think he's ever had an actual removal service to come. I know it's probably had, different agencies, but these people have trucks to remove the stuff.
I just want to make sure. These are the pictures you gave me just now, right?
Yeah.
Because I've got other color pictures in here. I just want to double check. Are you sure those are the pictures? And if they are, would you just write on the back the date that those were taken or somewhere in a corner, somewhere on?
Yeah, these, the pictures I took yesterday.
And so that was May the 5th. Would you just write that on the back of those or what have you? Look. Mr. Boyd.
Is that my phone? You got it.
All right. This is not a case I ever look forward to handling. You know that? I didn't. Oh,
That shuts it off. The head of shut off.
okay.
Turns on in the front.
I just want you to know, counsel, back on July the 30th, I set a review hearing date for September the 24th of 25 for him to have all these things done. Now here we are, it's in May. We're 8 months after that, 10 months after I placed him on probation. I'm glad to hear the garage is down. Trying to be positive. Would somebody,
Let's start with the good news first.
did somebody humor me here? How much time are you asking for?
2 weeks to 30 days.
Okay. Give me a date 4 weeks out, Heather.
4 weeks, we would have June 3rd, Judge.
That's in the morning. I'm off in the afternoon that day, right?
I don't have that marked. Did I miss something on that one? Let me double check.
Did I ever do one for the 3rd, 4th, and 5th? Oh, I screwed up.
Yeah, I
So-
don't have anything marked for that.
Well, I'm gonna be off the 3rd, 4th, and the afternoon of the 3rd, so we gotta keep that.
Okay,
light
so you're
in
off of the PM
Uh,
on the 3rd. Okay.
Correct. I'll get you those today. I thought I took care of
Okay.
it. We'll adjourn this to June 3rd at 8:30. So that's gonna be a jail start date though, of 80 days unless I suspend it. Okay?
Is that just a jail start, or do you want to do it as another review, or just a jail start date,
Jail
Judge?
start / review hearing date, and you'll be
Okay.
here that day, right? Ms.
I
Patel?
think I am here on the third.
Good, that's when we'll do it.
Yeah, just speak clear, that includes everything,
Everything on that list, and I want you to give Ms. Patillo a copy of that. Mr. Boyd, don't go anywhere until you talk with your lawyer further, will you please?
Okay.
Your Honor, Mr. Wayne has a question.
thank you, Judge.
Thank you, Judge.
Okay, thank you. Good luck. Do you have a question?
Yeah, good morning. Maybe your question?
Sure.
Alrighty, that's the latest on Hoarderman. Ashley, if you would be so kind as to make a note of the date. Looks like you already have, so thank you. And we'll follow back up with him in 30 days. Okie dokie, let's go to Judge Simpson. Say good morning to him.
For the people, regarding the people's conflict between this honorable court and the office of the public defender, while the people do not believe that any such conflict exists, we make this waiver in the avoidance of all doubt.
Mr. Brekovich, good morning. Good morning, Mr. Brekovich. It's nice to have you here.
I know, I'm very happy to be here too.
Are you? Let's see if we can change that. All right, go ahead.
Assistant Public Defender Nick Brekovich on behalf of the Lawson County Public Defender's Office. Likewise, the Office of the Public Defender does not believe there is a conflict between this honorable court and the Office of the Public Defender. However, if one does exist, we would waive any conflict.
Thank you. And the court for its part also does not believe there's conflict either under the Michigan court rules or the cases decided thereunder. To the extent a conflict does exist, given the waivers, the court will consent to hear the matters. Court does call the case. People versus, is it Nevaeh Krieger?
Morning, Your Honor, Raymond Cook for the
Right.
Your Honor, figure who's approaching. Ms. Krieger, please state your name for the court. State your name for the court. Nevaeh Krieger.
Thank you.
Your Honor, I'm asking for adjournment to get the remainder of discovery.
Turn this matter to
May 20th.
May 20th, 2026, 9 a.m.
Thank you. Have a great day.
Bound with this condition. Court does call the case of the people versus Rebecca Dooley.
Your Honor, Raymond Cook for the people. Your Honor, Joe Simon.
Wait, I didn't even see you.
Yeah, I was hiding. Joe Simon on behalf of Ms. Dooley, who appears by Zoom. Rebecca, state your name.
Rebecca Dooley.
I have before me a plea form that indicates that she's going to be pleading to operating while intoxicated second offense. That's count 3. Well, the 1-year offense. Upon her successful plea to that charge, count 2 would be dismissed.
This is the new complaint. Your Honor may remember this was a remand for this plea from.
And count 1 was already.
That's right. That's right. And also, Your Honor, on that plea form, I made sure Ms. Dooley has it electronically. I sent it to her. She gave me her authority to assign it on her behalf, but she's reviewed it.
The prosecutor will recommend community service in lieu of jail.
Right. So just to refresh the court, I know the first memory is pretty shocking. It's great. She's relocated permanently. She did about over a year ago. I don't remember the exact span of time to was it North Carolina? But yes, North Carolina.
North Carolina.
And
so she's a Tar Heel.
And all of
that's right. I remember that.
Yep, and all of her.
I don't like Tar Heels.
Oh, all of her.
My Maryland days. But go ahead.
I think turtles like.
Interrupt you.
Turtles like tarple. But anyways. Anyway,
I don't know what it is. It's odors. Anyway,
all the recovery that she's been doing, we're going to make sure gets to your probation.
Right. All right, ma'am, if you can please raise your right hand to be sworn. Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
All right. State your name again for the record, please.
Rebecca Dooley.
All right. You can put your hand down. Ma'am, it is this court's understanding that you're going to be pleading guilty to the charge of operating while intoxicated second offense. That is a misdemeanor punishable by up to 1 year incarceration, a $1,000 fine plus court costs. The court could order rehabilitative services or community service that the court deems necessary. The court could order your vehicle immobilized, could order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. You understand all of that, ma'am?
Yes, Your Honor.
And understanding that, do you still wish to plead guilty? Bless you.
Yes, Your Honor.
And to that charge, how do you plead?
Guilty, Your Honor.
And you understand that by pleading guilty, you will not have a trial of any kind.
Yes, Your Honor.
All right, you signed an advice of rights form or had one signed on your behalf?
Signed.
Yes, Your Honor.
All right, any question regarding any of those rights?
No, Your Honor.
All right, you understand that you're giving up all of those rights, inclusive of the rights that are contained under paragraph 5.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
No, Your Honor.
Has anybody promised you anything other than what's been stated here today on the record to get you to flee?
No, Your Honor.
Anybody threaten you or coerce you?
No, Your Honor.
You're doing this voluntarily and of your own free will?
Yes, Your Honor.
And also because you believe that you're indeed guilty of this offense?
Yes, Your Honor.
On September 17, 2024, at the location of Washtenaw Avenue in Pittsfield Township, Washtenaw County, State of Michigan, were you operating a motor vehicle?
Yes, Your Honor.
Prior to operating that motor vehicle, did you consume intoxicating liquor?
Yes, Your Honor.
Do you recall what you had and how much?
I drank vodka, but I do not recall how much, Your Honor.
All right. Were you stopped by the police or was there an accident?
There was an accident, Your Honor.
All right. Ultimately, the police arrived?
Yes, Your Honor.
All right. Were you arrested?
Yes, Your Honor.
All right. Were you taken to the hospital for a blood draw?
Yes, Your Honor.
And what were the results of that blood draw?
0.17, Your Honor.
All right. Do you have any reason to dispute those blood test results?
No, Your Honor.
All right. Had you previously been convicted of operating while intoxicated on or about November 13th, 2008 in the 61st District Court?
Yes, Your Honor.
Wait, is that the right?
Or the April date? Which date are we using?
We can use either one because we're past the April anniversary. That's what we wanted to do. So.
Right.
So I guess technically for the charge, it should be the April date.
It would have to be, you're right. So were you convicted of operating while intoxicated on or about April 18, 2019 in the 61st District Court?
Yes, Your Honor.
All right. Ma'am, I do have to advise you that if between the time of my acceptance of your plea and the time of sentencing, if you commit misconduct as defined under the Michigan court rules, you could not withdraw your plea and the court would not be bound by any sentence recommendation or evaluation. You understand that?
Yes, Your Honor.
All right. Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
And have I complied with the court?
Yes, Your Honor.
Yes, Your Honor.
Court will accept the defendant's plea to count 2 or to count 3. Count 2 is dismissed. With count 1, so the record's clear, having previously been dismissed. Defendant is referred to Von Swartz for an alcohol screening and assessment and the victim's impact panel. Sentencing in this matter will be June 10th, 2026, 9 a.m. 9 a.m.
Your Honor, I know you want us to do it in writing, which we will, but we'll be requesting a Zoom appearance for that as well.
Yes, I understand.
Thank you.
All right. Thank you, ma'am.
Thank you, Your Honor.
Hold on a second. Do I have probation into? All right. So ma'am, hold on the line. We're going to put you into a breakout room with my probation department so we can start the process.
And
okay?
if I can just state for probation's purposes, we already have the Von Swartz assessment. We'll be forwarding that as well as everything else.
All right. First. All right.
Thank you, Your Honor.
Thank you, ma'am. We'll
Thank
get
you,
you
ma'am.
moved into that room shortly. Court does call the case of the people versus Joshua Golden.
Morning, Your Honor, Raymond Cook for the people.
Good morning, Your Honor. On behalf of Mr. Golden, attorney.
Sure. You froze up there, counsel. Mr. North, you broke up there.
Can you hear me now?
Yeah, we can hear you now. Go ahead.
Yeah. So, good morning, Your Honor. On behalf of Mr. Golden, attorney Nicholas North, PA 6482. Mr. Golden, if you could please unmute and state your full name for the record.
Hello, my name is Joshua Golden.
All right, thank you. What are we doing?
Your Honor, I'm thinking that we're setting this case for a final pretrial conference. I'd ask that you require the complainant's appearance.
Well, that would be if I set a final settlement conference. So, jury final settlement conference, June 5th, 2026, 9 a.m. Jury selection, June 8th, 2026 at 8:30. Both of those appearances are in person.
I'm sorry, Judge, you cut out for me. If you don't mind repeating it.
June 5th, jury final settlement conference is June 5th, 2026, 9 a.m. Jury selection, if necessary, June 8th at 8:30. Both of those proceedings are in person.
Okay. I appreciate it, Your Honor.
All right, thank you. Court calls the case of the people versus Joshua Wara.
Your Honor, Raymond Cook for the people.
Good morning, Judge Lori Margolis. On behalf of Mr. Wara, Josh, please unmute and state your name.
Joshua Wara.
All right, there you are. All right, you got a camera. All right, what are we doing?
So, Your Honor, there has been a global agreement reached by the parties in this. Part of that requires a plea on a case set for PCC tomorrow. I expect that will dispose of this case. So we're just asking for a date before that. I assume I'll be filing a nollie once the plea tomorrow goes through.
Okay. What's my next name? I'll adjourn this then to May 20th, 2026, 9 a.m.
Thank you, Judge.
Expecting that it all occur. All right, thank
See
you.
tomorrow. Bye.
All right. Joshua, how you doing?
Good, and you, Judge?
I'm doing okay. All right, we'll see you
Okay.
tomorrow.
All right, thank you.
Thank you.
Thanks, Judge.
Yeah.
Court calls the case. People versus Braisha Anderson.
Morning, Your Honor, Raymond Cook for the people.
Sherilyn Foster Tucker on behalf of Braisha Anderson. Your Honor, I don't believe she is in the courtroom or on the Zoom. I don't have an explanation for her absence at this time.
Bench warrant will issue for defendant's failure to appear. Bond will be set in the amount of $5,000. I'll give a 10% privilege on that.
Your Honor.
Court calls the case. People versus Julia Blevins.
Morning, Your Honor, Raymond Cook for the people.
No relation.
Sherilyn Foster Tucker on behalf of Julia Blevins.
Go ahead.
Your Honor, I did speak with her this morning that she was having some car issues, but she would be coming if Your Honor would.
What?
Passing the matter.
She was having car problems?
Yes, that is what she told me.
You believe her?
Yeah.
Of course she'd say that. Fine, I'll pass it.
Yeah.
It's probably a tire. That's what happens to all Blevins. Court calls the case. People versus Caleb Kishan.
Morning, Your Honor, Raymond Cook for the people.
Wait, what is that? This is not.
David I. Goldstein appearing on behalf of the defendant. Please.
Thank you.
We're asking for a final settlement conference. And I want to remind the court, I'm not going to be here in June. So the June 5th date would not work.
Did he tell me that before? No. He does that. He says, I'll remind the court. So he thinks my memory's going, but I don't think he's told me that. Okay, what are my next dates after that? Sir, you need to take your hands out of your pockets, please.
Oh, I'm sorry.
For jury files, correct?
Yeah. A long time ago. Jury final settlement conference, August 7th.
7th, Your Honor.
Yes, 2026 at 9 a.m. Jury selection would be August 10th, 2026 at 8:30. Oh, go ahead.
On this case did appear at the last FSC at the beginning of this month. Would his presence be able to be excused for the August FSC?
Yes.
Thank you.
Both of those proceedings are in person. All right, thank you.
Thank you, Your Honor.
Joseph. Court calls case is Robert Downer.
Morning, Your Honor. Raymond Cook was
Morning, Your Honor. Michael Vincent on behalf of Mr. Towne. Downer, state your name to the judge.
Robert Downer.
Thank you. Are you here alone?
Well, they're watching me here. They're watching me.
They're watching. Okay. All right. Just want to make sure you have proper supervision. All right. What are we doing?
Need a motion date. He needs to be arraigned.
Okay.
We do anything?
As to the arraignment,
Stands mute, Your Honor.
defendant having waived from a reading, standing mute. Court will enter a not guilty plea today, 6. Right. And you need a motion date. What is the motion?
Excuse me.
Pardon?
What's
the nature of the motion?
Tacking the blood test.
How soon will you have that motion?
Maybe towards the end of the month.
All right. The defendant's motion will be due by May 27th.
Yeah.
Prosecutor's response will be due by June 12th. I'll set a motion hearing date. What's my trial date in June?
Is the 24th.
Hearing on the motion. And pretrial will be set for June 24th, 2026 at 9 a.m. All right. And as to bond in this case, alleged BAC.
071, there was a 3 in the vehicle crash, no known. Here's
Give me the BAC again.
07.
And 3 vehicle crash.
Yes, Your Honor.
Defendant's bond in this case will be set as a $10,000 personal recognizance bond. I'll order standard conditions, including no assaultive behavior or possession of any weapons. There's to be no use or consumption of any alcohol, recreational marijuana, or any illegal drug. You understand that, sir?
Yes.
You are also to report over to community corrections for placement on a sober link testing device. You're to do that within 24 hours.
Soberly. I'll tell you alcohol.
All right. Thank you.
Thank you, Your Honor. Keep going.
Court calls case, People versus Byron Blair.
Morning, Your Honor. Raymond Cook for the people.
Good morning, Mayor. Police Court, Your Honor. Attorney Damian KSP number 85852.
appearing on behalf of Mr. Brian Blair on one matter and
Ron Brown appearing on behalf of Mr. Blair on the other.
Do I have to?
One, Mr. Brown is, he's was adjourned.
Oh. Sit down.
Okay, all right. All right. Mr. Blair, is he here?
Is that on Zoom? Thought he was gonna be on Zoom today.
We don't have.
When I spoke to him.
Blair? Okay, well, hold on a moment.
Okay.
When was Mr. Brown's case adjourned to? Because I bet you. I'm wondering if he received notification of that adjournment and that's why he's not here today.
Okay.
May, all right.
20th of May.
Yeah, I'll adjourn this out then to May 20th,
Okay, thank you, Your Honor.
2026, 9 a.m. That way both cases are together. So I said there was last adjournment. That will be the last.
That's the final settlement. Okay, May 20th. Thank you, Your Honor.
Thank you. Court does call the case of People versus Abdurrahman Banda.
Ron Brown appearing on behalf of Mr. Bond.
Here,
Not sure.
Banda. It's not here. Bench warrant will issue for defendant's failure to appear. Bond will be set in the amount of $5,000. I'll give a 10% privilege on that.
Thank you.
Alrighty, everybody. Good morning once again. My name is Dan. This is TCF Live. If you are new out there this morning, do take a moment and say hello to everybody in the chat. We're a friendly folk here. You've stumbled across one of the greatest communities in LawTube. And I'm not just saying that because it's the one I run. It's a really good set of people. Well, thank you, Ellie, for completely changing my screen over there. That was nice of you. Let's change it up, though, for a minute. Let's go down to Lake County, Ohio. Judge O'Donnell has a contestant. Let's see what's going on there.
26 CR 346. The defendant is present in open court with his attorney, Mr. Matthews. We are here today for an in-court arraignment. When the defendant was bound over through the Painesville Municipal Court, his bond was set at $10,000, 10% cash surety. It was then updated that he was to come into the adult probation department and test weekly. The probation department reached out to the state and made me aware that he had tested positive for marijuana on 3 separate occasions. So on April 22nd of this year, the state did file a motion to revoke the defendant's bond. That was granted. And when we prepared the paperwork for arraignment, we are continuing it at bond revoked. In the meantime, he was indicted in a 2-count indictment, count 1 being possession of cocaine, a felony of the 4th degree with the attached forfeiture specification, and count 2 being tampering with evidence, a felony of the 3rd degree.
Matthews.
Thank you, Your Honor. Mr. Sturdivant would waive the reading of the indictment, any defects in time or service, and enter a plea of not guilty to all charges.
Not guilty plea will be entered. Mr. Matthews, bond.
Thank you, Your Honor. As was indicated, Mr. Sturdivant's bond was revoked as a result of those positive marijuana screens. Mr. Sturdivant indicates that he has not continued to use marijuana while on bond. He was positive on March 16th at the Painesville Municipal Court. Indicates that all positive tests from that point forward are the result of residual marijuana in his system. He does live locally at 192 Casement in Painesville, and to his credit, has reported weekly for these drug screens as he was ordered, and also upon being notified that there had been a warrant put out for him, did still appear on May 1st for his screen, knowing that he would be arrested. He would ask the court, in light of those circumstances, reinstate his bond at its original level, Your Honor.
Ms. Contour.
Your Honor, the state did file the motion to revoke bond. Our position has not changed since we
All right, Mr. Sturdivant, where do you live?
192 Casement.
Where do you work?
Work with my friend. He owns his own company. We clean our houses and stuff.
You got a cell phone?
Yeah.
All right, I'm going to reset your bond. The 10,000 cash or surety or 10% will be
That portion of it will be reinstated. You are, as a condition, you are to test randomly with the adult probation department when they call you. When they call you to come in and take a test, you have to report within 4 hours and take the drug test. If you don't comply with that condition, then you'll be back where you are right now. You understand that?
Yes, sir.
Anything else, Ms. Contour?
Nothing further.
Mr. Matthews?
Just, I want to be clear, he's no longer reporting weekly, it is now just random.
Just random.
Thank you, Your Honor.
Right?
Alrighty, short and sweet with Judge O'Donnell. Let's go back up to Michigan. We'll check back in with Judge McNally.
All right, Michael Carter Burke, 26I-415-304, 24I-702-893-FY. Mr. Burke, your name?
Michael Carter Burke.
Counsel?
DFTOP 82378 on behalf of Mr. Burke.
So he's going to plead as charged on, and Mr. Wayne, you're
Yes, sir. No, this will be a FY matter, but on behalf of Township of Groseal, Matthew Wayne.
but I also called the Groseal Township case, and you've offered possession of drug paraphernalia. Well, that's the original charge. That's what he's going to plead to, counsel?
Mr. Burke, is that what you want to plead to?
That's fine. Yes, yes, Your Honor.
If you plead guilty to that, the possible penalties are up to $500 fines, 90 days jail, costs, or all of those. Do you understand that?
Yes, 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 Your Honor.
You are presumed innocent. They have to prove you guilty beyond a reasonable doubt. You have the right to remain silent, right to a trial, right to a jury trial. You enjoy the presumption of innocence, and they have to prove you guilty beyond a reasonable doubt. By pleading guilty, you're giving up all of those rights. You're giving up your right to a jury trial. You're giving up your right to remain silent or testify on your own behalf. You're giving up your right to cross-examine their witnesses. You're waiving the requirement that they prove you guilty beyond a reasonable doubt, and you're waiving the presumption of innocence. Do you understand that?
Yes, Your Honor.
You still wish to plead guilty
Yes, Your Honor.
to the charge possession of drug paraphernalia. How do you plead?
I plead guilty. I had it on me.
On April 30 of 26, were you on Macomb near Meridian in Groseal Township at 6:32 p.m.?
Yes, sir.
Were you in possession of drug paraphernalia? And if
Yes,
so,
sir.
what were you in possession of?
I had a pipe on me.
And you
Nothing in
used
it,
that,
but just a pipe.
and you used that to smoke crack cocaine, correct?
And yeah, I hadn't done it in about 7 days, but yeah, it was in my possession.
Are you on probation or parole right now?
No, sir.
Anybody force you to plead guilty?
No, sir.
All right, I'll accept that plea. You're all set. You can leave unless you want to tell me, Judge, I would prefer you do this or that. It's up to you. I'm the sentencing.
Nothing, Your Honor.
You're all set.
Thank you.
Thanks a lot. Thanks. Okay, so that one, now I've got this other one here where he just didn't pay and he has to serve 275 more days. I ordered him that's what the sentence was. It's a 1-year misdemeanor that he was convicted of. It was attempted unlawful use of a motor vehicle, and they dismissed the UDAA, so that made it a 1 year, and he served 90 days to begin with, 23 days credit, 67 more. I told him to pay 50 per week starting November 7th. I told him to come talk to me. If he didn't have the money, he didn't either. So how was he going to proceed on that?
I've got some bunch of stock I can sell. That way I can pay all the fines. But right now, until I sell my stock, it's in my mom's estate, probate. I've got about 800,000 in stock. So I'm trying to sell that to pay all of my debt. I was going to hire an attorney and try to get everything organized, but right now, until I sell the stock, I'm kind of limited funds.
Did you say 800,000?
Yeah, my mom left me a lot of stock.
Why didn't you?
It's all in my mom's trust or her estate. And me and my sister have.
Stop for a second.
Yes, sir.
Why did you come and talk to me?
I should have came, sir. I apologize.
What else is he in custody on right now?
And what else is he in custody for? I believe it's this case.
I said 6,010%.
I've got the bail money in my sister sent me the money to be bailed out. I just haven't went to the ATM to do it yet. But since we're already in front of you, so we're just,
Oh,
I guess
yeah.
that's me.
Slow down, will you? You
Yes,
live
sir.
on Grace Drive still, apartment B8?
Yes, I do.
Your Honor, his sister is his conservator. He doesn't have a guardian. I don't know if the court would be willing to give him time served on the case he just pled guilty on. Your Honor, I would ask if he could potentially be released, because if he can get with his sister,
All right,
then.
good enough, good enough. Mr. Burke, how old are you now?
I'm gonna be 51 in June, sir.
How have you enjoyed your stay at the Wayne County Jail?
I'd rather be back in Groseal, but it's been okay, sir.
It's been okay?
I'm just handling it the best I can. I'm getting older, so it's hard to sleep on these bunks and stuff, but I'm doing what I can.
Listen,
Yes, sir.
it's kind of time to grow up, don't you think?
I agree, sir. Yes.
I'm gonna reduce it to a $6,000 personal bond. I'm gonna set this for hearing. And I'm gonna release him on, he's got a PR bond on the other. So send over an amended minimus, if you would, Heather, ordering him to be released. I'm reducing that to a 6,000 PR bond. We'll set these for sentencing. I'll give you some time. You don't need to be afraid. If you don't have the money, you should have called like I told you at the time of sentence. I tell everybody that. Why would you have done that? I don't understand it. Let's set
I
this.
didn't do it. I'm sorry.
Let's set this for, you didn't do it on purpose. What do you mean?
No, I didn't say purpose or anything. I said, I apologize. That's what I said.
All right, we're gonna set this for hearing. You're gonna be here May 20th?
I don't think May 28th.
No, 20.
She should be. I believe she's our new house counsel for Brownstown. Let me take a look.
20th that Wednesday?
Yeah.
I'll be here.
Good. Let's set it for 9 o'clock in the morning on the failure to pay and the sentencing on the drug paraphernalia. I don't need a pre-sentence report on that. I'm just gonna set it for May the 20th at 9 a.m., no PSI, no screening on that. And we'll mail him notice, send over the amended minimus. You don't have any other holds, right, sir?
I've got one in Ferndale, so they might come get me, but I don't know. I mean, it depends.
That's what I'll do, May 20th, and I'll have him. So I'm not saying, obviously, if he's got other warrants, you're just sending this over and saying I'm reducing this to a PR bond, Heather, okay?
Okay, Judge.
All right, that's what I'll do, May 20th at 9. I hope you get released. Show up here, we'll work out something, even if you don't have the money.
Okay, I understand.
You got it?
Yes, sir.
All right, good luck. Thank you.
Thank you, Judge.
Thank you.
Marie Ann Cook McKaylee. Is it Marie Ann McKay, or is it McKaylee Marie Ann Cook? 25W840880A, and then I also have 25B149846A. Where's she at?
I'm on the Zoom.
You have to start your video, ma'am. What is your name?
McKaylee.
Okay, you got to tell me your full name.
McKaylee Cook.
Yeah, I need to see your face. You're moving the, what are you on your phone?
Yeah.
All right, just keep that still so I can see you, okay?
Mm-hmm.
I'm not sure she's got a show cause.
Yeah, it's just it's about my payments. I haven't been able to make any payments because I still don't have a job.
Why not?
Because I can't even
I
drive.
sentenced you on December 3rd at 25. I
I
said to
can't
pay.
drive nowhere. I don't have nobody. It's literally just me. I can't rely on nobody to come get me. It's like,
Man, how you gonna get a car?
I have a vehicle. My license, it was stuff with that. My license is on a restricted right now. I'm working on getting my insurance turned back on so I can get new plates so I can get to a job.
You live in Monroe. It looks like you kind of live downtown there, right?
Yeah.
Why
I've
in the world
applied,
aren't you getting
I've
a job?
applied to 158 places.
You what?
I've literally applied to like 158 places. I've applied everywhere in Monroe. I've been applying to places in Woodhaven, Taylor. Like, it's
Why
not
aren't
like I'm just,
Why aren't they hiring you? Have you figured that out yet?
no. I tell everyone I have open availability, everything.
Do you have any family in the area?
No.
Where's your family at?
My grandparents live in Virginia. My mother lives here, but no. So it's just me. I can try to make a payment. I babysit sometimes on Fridays.
Here's what
but
I'll do for you. Listen, I'll let you do community service. Okay?
Okay. Okay.
You're to pay. I'm going to dismiss the show cause on my case, 149-846A. How much she owes what, Heather? 236?
On the 609A.
846A.
846A is 201.
You pay $200 or serve eight hours of community service by June the 20th. On Judge Heston's case, what does he owe on that one? It looks like 465, right?
That's correct.
You're to pay 465. Wait a minute, I gotta have to do more than 8 hours, don't I? Yeah, I gotta have to do more than 8 hours. Yeah. You're gonna have to do 14 hours of community service or pay up $200 by June the 20th. Do you understand that?
Okay.
Then on the other case, listen, on Judge Heston's, you're to pay 465 or serve 32 hours of community service, 34 hours of community service by August the 10th. I'll dismiss these show causes, okay?
Okay. Thank you.
But you got to take care of that. You know where you can do community service? It has to be a non-profit organization. St. Vincent de Paul, Salvation Army, a church, Habitat for Humanity, an animal shelter. I could care less where you do it, but it has to be non-profit. You can't go work as a receptionist at a dentist's office, have them send us something telling us that you completed community service. That's not community service. It has to be non-profit, okay?
Okay, thank you.
Good luck. Thank you. Eddie Lee
Thank you.
Darnell Banks Jr., 26B147417A. Can I also have Dennis James Hogan up here, 26B149108? Sir, good. How are you? Your name?
Thanks.
You're charged with driving an unregistered vehicle. Come on up here, Mr. Hogan, and tell me your name, please.
That's James Hogan.
All right, Mr. Banks, you're charged with two files. You have 26B147417A and B. Mr. Hogan, you have one file, 26B149108. Your charge here, Mr. Hogan, is driving on a suspended. Mr. Banks, your charges are driving on a suspended and driving an unregistered vehicle. Each one of you have the right to an attorney. If you want one, I will give you one. If you don't want one, I'm going to arraign you, explain the charge, the possible penalties, and send you to the prosecutor to negotiate. Do you understand what I said, Mr. Banks?
Yes, sir.
Mr. Hogan? Do you want a lawyer, Mr. Banks?
No, sir.
Do you, Mr. Hogan?
I would like to speak.
We're going to give you one. Take them to a lawyer, John, and your lawyer will speak to you. Your lawyer will go in and talk to the prosecutor, okay? Mr. Banks, you are charged with operating a motor vehicle that was unregistered on westbound Sibley, east of Beach in Brownstown, April 15 to 26 at 10:55 p.m. They think your vehicle was unregistered and they think you were suspended. Suspended license is punishable by up to 500 fines, 93 days jail. Costs are all those in 2 points. Driving an unregistered vehicle is punishable by up to 100 fines, 90 days jail. Costs are all of those. Do you understand that? Did you sign, read, and understand the advice of rights form here? If you plead guilty, you will be giving up all those rights and there will be no hearing or trial. Do you understand that? Or still wish to waive your right to a lawyer? I'm entering a not guilty plea. I'm giving you a $250 personal bond. You don't have to post any money. You cannot leave the state without the consent of the.
You're just pleading guilty, I'm sorry, not guilty.
Hang on. I'm giving you a personal bond. Okay, trying to help you. If you plead guilty, you're convicted of both. Go talk to the prosecutor. The worst that can happen is he tells you he's not going to offer you anything, or she tells you she's not going to offer anything. I'm not requiring you to post a bond. Do you understand that?
Yes, sir.
So you're going to go out in the hallway. We'll give this one to the prosecutor. And the other one, and then you'll come back in front of me either way after you talk to your lawyer and your lawyer talks to the prosecutor, okay? Thank you.
You take one always?
Yeah.
Correct.
Judge, do you have Miss Tremblay's case up there?
Who?
Miss
Yeah,
Tremblay
I
for
do. I kinda got
priority?
buried here. Give me 1 second. Erica Elizabeth Horvath, 26G77244. Yeah, I know. I just got a little backed up here. Defendant failed to appear. We're going to issue a show cause. This is the first miss, so you can issue a show cause on that one, Heather. Priority Waste LLC, 26B150671. Counsel, your appearance.
Good morning, Your Honor. Elizabeth Tremblay appearing on behalf of Priority Waste.
Sorry about that. I just got backed
Okay.
up. You're going to plead to overweight on behalf of the company, agreed upon fines and costs of $1,900, true?
Yes, Your Honor.
To that charge of overweight violation, responsible or not responsible?
Responsible.
Accept the plea, $1,900 due by June 6th. What will we do without Priority Waste having overweights? Are they taking any steps?
Yes, Your Honor. We are in the works of new ownership, and that new ownership will allow us to fix a lot of our vehicles.
Well, I mean, I don't want them tearing up the roads either. I mean, I
Yeah.
don't even pull up Priority Waste for me, will you, Sadie? I'm gonna just look up here and see how many overweight cases roughly that I've had with Priority Waste.
Oh.
And okay, that's 1 page, 2 pages, 3 pages, 4 pages. I mean, they're all 5 pages, 6 pages, 7 pages, 8 pages, 9 pages. They owe us some money too on some of these. I hope they're not overdue. If they're overdue,
They shouldn't be overdue. We have
keep going.
payment
You got,
schedule.
this is
so,
crazy.
Yeah.
I mean, I feel like we're a credit card company here, but they got to take some steps because I mean, they're either, at this point, it's just a blatant disregard for laws. And I'm going to trust that what you're telling me, and I believe you, you're a nice lady and a nice lawyer and all that, but I'm not going to continue to do this. I can make payments due the date that the police take. And then when they don't pay, I can start issuing show causes and executing on their trucks. That's what we can do here. I did it 15 years ago with regard to a company, and it stopped the nonsense real quick. Maybe it was 20 years ago now. But they're just tearing up the roads. I mean, I don't want to get on you, but this is crazy.
I understand, Your Honor.
I mean, they either blatantly disregard laws. There's no other ifs, ands, or buts about it. That's what it is. I know they're not misdemeanors, they're not criminal in nature, but I see these trucks all over, and I think to myself, when I see them as I'm driving home or wherever I'm going, boy, I bet they're overweight. I mean, it's a good bet, right? 12-1 in Vegas that they are. So that's what I think. All right.
I understand, Your Honor.
Enough said.
Thank you. You said
Yeah.
June 4th payment due or June 6th?
6th, June
Okay.
6th.
Thank you.
Thank you. Have a good day.
You too.
Malik Ravy Jones, 26B150630. pull out to Mr. Zelnick's case here. Will you, Sadie, find out which one he's got? Your name? Which one?
Oh.
Your name? You're charged with violation of an instructional permit, and you have the right to a lawyer. Would you like a lawyer?
Sir.
I'll go ahead and arraign you and send you to the prosecutor. It is alleged that on April the 14th of 26 that you did operate a motor vehicle violating the instructional permit. You violated the rules of your permit, and it says you were in an accident on Dix near King and Brownstown, April 14 of 26 at 12:19 p.m. That is a misdemeanor punishable by up to 100 fines, 90 days jail, costs, or all those. Do you understand that?
Yes, sir.
You just sign, read, and understand the advice of rights.
Yes, sir.
You plead guilty, you'll be giving up all those rights, and we're not going to have a hearing or a trial of any kind. You understand that?
Yes, sir.
All right, you still wish to waive your right to a lawyer? I'll enter a not guilty plea, $100 personal bond. You don't have to post any money. You cannot move the state without the consent of the court or violate a law. You must appear in court as directed. Do you understand all that?
Yes, sir.
All right, you're all set. Thank you. Brennan James Toth. 2. So go talk to the prosecutor. We'll bring the file over, okay? Brennan James Toth, 26B 149414.
Good morning, Your Honor. It was Zelenak, hearing for Mr. Toth. Mr. Toth, giving you. Brennan James Toth.
So is Brownstown here tomorrow?
She's coming in even if she isn't. Judge, this is a turfing case. The Trenton case is tomorrow. He was here a couple of weeks ago. This is one of these.
We're just adjourning it to tomorrow?
Until tomorrow.
Okay.
We'll waive the reading, ask the court to stand and be in a plea of not guilty.
I will do so, and I'll give him $500 personal bond. Sir, you cannot leave the state without the consent of the court or violate a law. You must appear in court as directed. I'm going to give you May the 7th. What time is that one?
Coming here right away in the morning.
I'll make it 8:45. Okay, whatever. We'll give you a notice. Go down the hall, get your notice, and you're all set, and I wish you well, okay?
Roger, thank you.
Good luck. Thank you.
Do you want me to take the file down?
Sure. Thank
Can I
you.
approach to get it?
Yeah, you sure can.
I thank Ms. Foley Carter for accommodating us.
Where you go.
Thank
Okay,
you.
thanks a lot. You can go down the hall and get your notice. You're doing good. Compton. Jonathan Glenn Compton. 265 W839357. All right. Is Mr. Compton out there somewhere, or is he here? or-
Yes, it's joining. There he is.
Mr. Compton, your name? I need your name, sir, Mr. Compton. I called your case.
Jonathan Compton.
Okay. What brings you here?
Need an extension on to pay the,
Mr. Compton. Yeah. This is a show cause hearing. I told you to pay $100 bi-weekly beginning January 16th. You would have told me you could pay that. You didn't pay anything.
no, I haven't been able to pay it. My
Didn't I
father-
tell you to call the court and go on Zoom with me if you didn't have the money? Did I not tell you that? Are you one out of the last 2,963 people that I didn't tell that to? Are you the only one that I didn't
No,
tell?
you told me, but
Then why didn't you do it?
I didn't have a way to call in. I went to Kentucky and I lost service and stuff.
Come
My
on.
dad,
Mr. Compton.
my
Mr.
dad got
Compton.
sick. I know it sounds.
You work?
No, not at the moment.
How are you supporting yourself?
Right now I'm taking care of my dad, and he takes care of everything else.
Sir, you're gonna have to get somebody, you're gonna have to get a job. You're gonna pay $40 a week. If you don't have the money, you call the court. I'll start it beginning on June the 1st, okay?
Okay,
I'll just, listen to me. Don't just say, "Shh, I got away with that," and not do anything. You're either gonna pay 40 per week or you're gonna call the court. You need to get a job or something. I don't know what to tell you. I don't have any answers for that. Okay,
All right, thank you.
good luck. Shelley Bacon, Shelley Francis Bacon, where's your lawyer? Eshelman, Garrett, Arthur Eshelman, 26B148944. Your name? Good morning. I have an assault and battery charge. You have the right to an attorney. Would you like an attorney?
Yes, yeah.
I'll give you an attorney. You go out in the hallway, we will set you up with the lawyer, okay? All right, and then either way, you're coming back in front of me, okay? Thank you, thank you. Is Jacob Douglas here?
Yes, Judge.
People against Jacob Michael Douglas, 24B147075. A. Hang on. I got 24B147048A, 24B147075A, 24B147048C, 24B147048B. And then I've got 24B147075B. All right, your appearance.
Thank you. Good morning, Judge. Attorney Thomas Courts, P77177, appearing on behalf of the defendant.
Mr. Douglas, your name?
Good morning, Your Honor. Jacob Douglas here.
Hang on. You went over and got printed? Did you go over and get printed at Brownstown?
Yes, sir.
Mr. Quartz, in the future, you either need to be in the same room with Mr. Douglas or you need to both be in person, okay?
Oh, absolutely, Judge. My apologies.
We'll adjourn this 2 weeks to May the 20th, Heather.
Okay, Judge, we could
It
do, yeah, okay, go ahead.
8:45, okay, or not?
We kind of have a lot already. If you want to move it to like 9:15.
Okay, 9:15, Mr. Quartz, all right?
Yes, Your Honor.
All right, so I'll just make a note of that. I'm only putting it in the 40488 file. If you could write the rest of those down there, Heather. He still owes the court $282 on the civil infraction that's been outstanding now since October of 23. All right, so have a conversation with them, will you please?
Absolutely, Judge.
All right, we'll see you guys on that date. Thank you.
Thank you, Your Honor.
Waste Management, 26B150802. Counsel, good morning, your appearance.
Good morning, Your Honor. Sean Powers, P42752, on behalf of Defendant Waste Management.
All right, so you negotiated this. This would be a plea to overweight and the agreed upon fines and costs of $1,900, right?
That's correct, Your Honor.
You're authorized to enter that plea on their behalf?
I am, Your Honor.
The charge of overweight, responsible or not responsible?
Responsible, Your Honor.
Plea is accepted, $1,900 due June 6th, okay? Have a
Thank you,
good
Your Honor.
day.
Have a great day.
Thank you.
It's TCF Live. It's Wednesday. We've got 2 hours and change in the books already. We're in the final hour. It's actually a relatively quiet morning out in Courtlandia, so we're going to continue to ride with Judge McNally for a little while.
So you have a charge here of reckless driving and you have a charge here of leave the scene of a property damage accident. You have the right to an attorney on these. Would you like an attorney?
Yeah.
Okay, we'll set you up with a lawyer. And you are all set. You go out, yeah, go outside the hall there and you'll speak to the lawyer, okay? It'll be a few minutes. All right, I need Ms. Foley Carter in here. Jackson Farrell, 24B82280. Good morning, Mr. Farrell.
Good morning.
Your name, sir?
Yes.
And, okay, so we adjourned the review hearing. for March the 25th. It looks like. You have the right to a lawyer. I'll be happy to provide you with one at public expense. Would you like a lawyer?
Yeah.
Okay, we're gonna give Mr. Farrell a lawyer. Can I have your names again, please?
Caitlin Foley Carter, Johnson Township.
Rob Harrison, yeah, Brownstown Township.
How we doing on this one? Just,
We're not doing well, Judge.
I thought he was making some progress. All right, whoever our lawyer is today, is that gonna be Ms. Patillo, Heather?
Yes, it is, Judge.
Okay, sir, you can go out in the hallway. We're gonna give you that lawyer, and then you'll talk to the lawyer, and then you'll come in here, okay? Okay, thank you.
Thank you, Judge.
Thanks. Where is the lawyer on Shelley Bacon?
You know, I just talked to her outside. She said she can't find him. And he was here about 15 minutes ago. Because he came in and checked with me. And then she just went out there and she said she can't find him, so I don't know where he's in it. And that was scheduled for 8:30.
You know where Mr. DiMaggio went?
I don't. I didn't tell him connected.
I know, he was in here for a minute.
Get on it real quick. You don't have an FR file, could be in.
No. Eddie Lee Banks. Eddie Lee Darnell Banks Jr., 26B1474417 A and B. All right, your name, sir?
Eddie Banks.
So they're gonna dismiss the driving an unregistered vehicle if you plead guilty to driving on a suspended. You sign the bottom. Is that what you want to do?
Yes, sir.
If you plead guilty to driving on a suspended, I will dismiss the driving an unregistered vehicle. Possible penalties are up to $500 in fines, 93 days jail, costs, or all those in 2 points. Do you understand them?
Yes, sir.
And again, you signed and read and understood the advice of rights?
Yes.
If you plead guilty, you will be giving up all those rights, and we are not going to have a trial of any kind. Do you understand that?
Yes, sir.
As I said before, I'll say again, you have the right to a lawyer. If you want one, I'll give you one. Do you want a lawyer? To the charge driving on a suspended, how do you plead?
Yes, sir.
On the 15th of April of 26, were you operating a motor vehicle on Sibley westbound east of Beach in Brownstown?
Yes, sir.
Was your license suspended?
No,
Was your license suspended? Are you on probation or parole?
sir.
Anybody forced you to plead guilty?
No, sir.
Why is your license suspended?
Just years of being young and, just not, doing the right thing at first. As I get older, I'm trying to, do the right thing. And I was just riding my mini bike. I was unaware that it was illegal. And at the time I was DoorDash and just trying to make a few dollars for my family. And when they stopped me, I was on the side of the road. I wasn't even riding, but I still had it. So, But yeah, I was just overtime driving and stuff. That's why they're suspended. But I'm working hard now to try to get everything taken care
Do you
of.
know where you have to go?
What, to get my license?
Yeah.
The Secretary of State, right?
Well, you got to go take care of your ticket, start in Taylor.
Yeah, I know.
You got to take
Log
care,
in once I leave here.
you got to take care of that ticket and pay your clearance. And then you didn't comply with the judgment out of Romulus, it looks like. So you were suspended.
Yeah, I was telling the prosecutor,
That's a no insurance. So you got to take care of that.
I understand. Yeah.
Well, you're just giving away your money. You have,
No, they said I was young, just not thinking.
you're still young, aren't you? What are you, 26, 25?
26. Just younger, not making the right, the better decisions, So I'm on track now.
Anything else?
Oh, you're right.
100 fines, 125 costs. I'll go light on you. 75 victims' rights, $50 justice assessment, 350 or 90 days. You go take care of those tickets. You got warrants out. You got to go take care of those tickets.
Look, Brian,
You have all this to pay? Where do you work at?
right, I was DoorDashing, and it was decent, and I would, ride my bike, just, I was making decent money, but right now, since I can't ride the bike and I don't have a car, I'm unemployed right now, but I do like construction work and yard work with my uncle on the side, so I can easily make money.
50 a week starting June the 1st. If you don't have the money,
Any way we can do 40?
I'll do 40.
Okay, thank you. Got it.
Listen to me. If you don't have the money, no problem. Come on in and talk to me on it before the due date, or call the court. You and I will go on Zoom. If you know how to operate Zoom, I'll give you an extension. I just don't understand. I tell everybody that, and everybody says they understand, and then a decent percentage don't pay and don't call and don't do anything.
This is my first time even having anything for this district, and the other things, I ended up moving to Ohio for a while. That's why I couldn't even, they were sending mail to my other address and I wasn't getting it, so I didn't have no idea what days or, nothing. That's the only reason I have the warrants for Taylor and Romulus.
All right.
I'm in Michigan now, so I'm about to be taking care of everything.
I wish you well.
Thank you, Brian.
Good luck. Good luck.
That's it.
Yep, you're all set.
This last case was brought to you by DoorDash. Do you think that food prices are out of control? One might say criminal. Do you feel that you would do well by supporting criminals? If so, choose DoorDash for all your food needs. DoorDash, employing the world's finest since 2013. Now back to court.
If you need more time, call the court. Kitchen Francis Bacon.
What about paying? Do I deliver in person?
They'll explain all that. Go down and talk to them. You can do it online, you can do it in person, but they'll tell you any fees associated. Yes.
Okay, thank you, Your Honor.
You're welcome. You too, thanks. Shelley Francis Bacon, 263-149-831. I don't know where you went. Where'd you go, Mr. DiMaggio?
The circuit court on Zoom.
Okay.
All right.
All right. Everybody's appearance here?
Andrew DiMaggio, Street Court 5619. We have Michelle Jason.
Ma'am, your name? So you want to apply for sobriety court? You think you have a problem?
Yeah.
Well, I don't want people in sobriety court that don't think they have a problem. So I'm telling you, it's a lot. Do you understand that? I'm not trying to talk you out of it. But I don't want people getting in sobriety court that think it's just kind of like going through the motions in regular probation, because it's new. You had one 3 years ago, right? Drunk driving or impaired? 23, it says on here. So are you aware of what it entails?
Yes.
Did you?
Very rigorous program. She understands that. But in their situation, she needs a license.
Yeah, I know, but the license is not a reason why I want somebody to do it. I want to be clear about this. You're going to be, it's a lot of work. And I only want people in here that are doing it for the right reasons, and that isn't, acquiring a restricted license is not one of them. Gaining lifelong sobriety is the reason you want to get in here. If that isn't the reason.
Well, my situation, my son doesn't drive and I'm a single parent. And I'm the sole provider for my household. And I have a lot of medical appointments coming up too. And I just been under a lot of stress.
I think, Judge, this is very helpful of the stress you're dealing with positively, not drinking.
Right.
I'll take your plea, calling the prosecutor, John. Tell her about 5 minutes. I'll take your plea. If you plead guilty to operating while impaired, the prosecutor is going to move to dismiss the original charge. Operating while impaired is punishable by up to $300 in fines, 93 days jail, 360 hours community service. Court costs are all 4 points, license suspension or revocation in accordance with your record. Your vehicle could be or might have to be immobilized depending upon your record. In fact, I will have to immobilize that 2015 Ford. Do you understand that?
Yes, I'm just worried about it. Like I said,
I can't do anything. I'm required by law to do that. Do you understand that? Do you understand that? And you understand all the rights on the advice of rights form? Did you sign it, read it, and go over it with your lawyer? And you understand you plead guilty, you're giving up all of those rights, including your right to a jury trial?
Yes.
All right. Any questions before we go on?
No.
To the charge of operating while visibly impaired, how do you wish to plead? Were you operating a motor vehicle on January 22 or 26 at 9:06 p.m. on Allen near King in Brownstown?
Yeah.
Prior to that, did you drink alcohol? And if so, what did you drink and how much did you drink?
I had a shot when I first got there.
Shot of what?
It was a mixed shot. Mixed drink shot. And then I had,
What kind of alcohol?
I don't know what it was. It was called it.
Where were you drinking?
Drink saloon.
In where? What in Brownstown?
Yeah.
Okay. And then what happened? How much more did you drink?
I had 3 glasses.
Okay. You feel like your ability to operate the vehicle was impaired because of your alcohol consumption?
Yes.
And did you take a breathalyzer or a blood test? And counsel, what were the results of that? Were they, thought I read 0.15 here. 0.157?
That sounds accurate, yes.
And you stipulate to the accuracy of the plea for purposes of this plea?
So stipulated.
I'm sorry, stipulate to the accuracy of the breathalyzer.
I will stipulate the accuracy of the breath.
Are you on probation or parole right now, ma'am?
No.
Anybody force you to plead guilty or promise you anything to induce you to plead guilty?
No.
And you're agreeing to go into sobriety court?
Yes.
And has she been going to AA twice a week? Now I need her done. Do you have proof of that?
Yes, I have a.
Have you shown it to your lawyer yet?
Yeah.
Have you seen it, Mr. DiMaggio?
Yes, I have.
So
I recommend it to my even when the case just started.
has she been going since March the 19th? Let's see, that's about 7 weeks, I suppose, give or take. Has she gone at least 14 times since then?
I believe so, and in fact, he was in the hospital over the weekend, so that you would have a couple more. She was developed.
Okay. All right, I'm gonna accept your guilty plea to operating while impaired. I find it to be an accurate plea. I do need to inquire of the prosecutor whether or not this is still being offered if she's not getting into sobriety court. I'm sure she will. Ms. Foley Carter, your name? I just want to make sure. They're talking about doing this sobriety court for a license. That's not a good reason. I just want to make sure if we don't ultimately end up accepting her, this plea offer is still good. Is that true?
That's true. It's not contingent about
Right.
being in disgrace.
So I'll take your plea. You're going to go over there. We're going to put you through a bond phase. You're going to start going AA 3 times a week, testing 3 times a week. You're going to be on a sober link. They're going to set you up. You're going to be in treatment and you're going to have to start coming to status reviews with me starting next week, either in the afternoon on Tuesday at 3:00 or Wednesday morning at 7:30 in the morning. Okay? Well, give me a sentence date out, Heather, about 6 weeks.
Okay, Judge, that would put us at June 17th.
At 8:30 in the morning. Is that good with you, Mr. DiMaggio?
That's a good day.
June 17th at 8:30. Okay, I do have to order a mobilization. You're gonna have to give her an order. I'm gonna have to sign it. I have to order your vehicle immobilized for 90 days. You have to have that done within 7. I have no choice. And then at least when you're sentenced, that will kind of run concurrent with your the time before you can apply for a restricted, assuming that you get into sobriety court. Okay? All right. Anything else?
One
Anything?
question, Judge, though, if that immobilization, it's not to be today, it's within 7 days.
Within 7 days, and we'll give you the order. And they'll tell you who to call. You're gonna have to have somebody come and put a club on the steering wheel. You're all set, Ms. Foley Carty. Thank you. Okay, so go down the hall, get your notice. We'll give you the immobilization order. Meet with probation. Good luck. Sobriety court, I hope you make it. It's a tough program. I want you to be ready for it. Okay? You're gonna be blowing into that machine 5 times a day. You're gonna be going to test 3 times a week, treatment, AA, status reviews. You're gonna be in this building every week. With them 1 week, me the next week. Them 1 week, and I'm talking about them being probation, okay? I wish you well. Thanks, Mr. DiMaggio. Have a good day. Thank you.
She has at least 15.
Alrighty, friends. About a half an hour to go here at TCF Live. Let's change it up, though. back down to Judge O'Donnell in Ohio.
Seated. Sidretsky.
We're here in the case of State of Ohio versus Brandon Truett, case number 26CR59. Defendant is present in the courtroom, represented by defense counsel. We're here today for a change of plea. It's my understanding that the defendant wishes to change his plea to count 1, having weapons under disability, from not guilty to guilty. There's also forfeiture specification attached to that for the firearm, which I believe the defendant is going to be pleading guilty to as well.
All right, Mr. Reardon?
That's accurate, Your Honor.
Mr. Truitt, how old are you?
It's 30.
How far did you go through school?
I got an associate's degree in veterinary technology.
And are you a U.S. citizen?
Yeah.
Are
Yes.
Are you able to read, write, and understand the English language?
Yes.
Prior to coming to court, have you taken any drugs or alcohol or any prescription medication in the last 48 hours?
I have smoked marijuana.
When?
Yesterday.
Does it affect your ability to understand what's going on here today?
No.
Did you get a copy of this indictment?
Did I get a copy of this?
Yes.
Yes.
And you're pleading guilty to count 1, having weapon while under disability, and the forfeiture specification, is that correct?
Yes.
All right, before I accept your guilty plea, I need to determine that you know and understand the constitutional rights you'll be waiving, the consequences of your guilty plea, and the maximum penalty I could give you. And I need to be satisfied that your guilty plea is being made freely, knowingly, and voluntarily. I'm going to ask you questions. If you don't understand a question, let me know. If you want to talk some more to Mr. Reardon, let me know that, and I'll give you more time. You understand that?
Yes.
You have a constitutional right to have a trial, either to me or to a jury of 12 Lake County citizens. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If you go to a jury trial, all 12 members must agree to a guilty verdict before you can be found guilty. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If you go to trial, the prosecutor will call witnesses to testify against you. Do you understand the prosecutor must prove you guilty beyond a reasonable doubt at a trial?
Yes.
After the witnesses are done testifying for the prosecutor, you have the constitutional right to have your lawyer cross-examine the witnesses. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If you go to trial, you have the right to have witnesses come and testify for you. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If those witnesses refuse to come to court, I'll issue an order called a subpoena to make them testify. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
You have the right to testify at trial if you want to. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
You have the constitutional right to not testify at trial if you do not want to. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If you decide not to testify at trial, nobody is permitted to comment on that decision. Do you understand that?
Yes.
If you go to trial and you're found guilty, you have the right to appeal the guilty finding. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If you file an appeal, you have the constitutional right to have a lawyer represent you in the appeal. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If you could not afford to hire a lawyer, one would be provided at no cost. Do you understand that?
Yes.
If you file an appeal, you're entitled to have a transcript of all the hearings in this case. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If you could not afford to copy those transcripts, they'd be given to you at no cost. Do you understand that?
Yes.
If you plead guilty today, you will not have the right to appeal the guilty finding. Do you understand that?
Yes.
Do you have any questions about any of these rights?
No.
Do you still want to plead guilty to this charge?
Yes.
Do you understand by pleading guilty, you're fully admitting your guilt to the charge?
Yes.
You understand by pleading guilty to this felony, you're voluntarily giving up your freedom for whatever period of time I could sentence you to prison, to jail, or to community control.
Yes.
Having weapons while under disability is a felony of the 3rd degree. It carries a maximum prison sentence of 36 months and a maximum fine of $10,000. Do you understand that?
Yes.
If you plead guilty to the forfeiture specification, you're voluntarily giving up any right you would have to the item listed. Do you understand that?
Yes.
Do you understand that your felony conviction prevents you from owning or possessing a firearm?
Yes.
Do you understand that if a prison term is imposed in this case, you might have to serve a period of post-release control for up to 2 years under the parole authority?
Yes.
If If you are placed on post-release control and violate any conditions, the parole authority could send you back to prison for up to 9 months for each violation, up to 1/2 of my sentence. Do you understand that?
Yes.
If that violation is a new felony, then you could get an additional consecutive prison sentence for the violation. Do you understand that?
Yes.
If that were to occur, the maximum prison sentence for the violation would be the greater of 12 months or the time left under post-release control. Do you understand that?
Yes.
Do you understand that if a prison term is imposed, you are eligible for judicial release?
Yes.
I could place you on community control for up to 5 years, but if you violate any conditions, I could send you to prison for 36 months. Do you understand that?
Yes.
Has anybody promised you that I would be lenient on you just because you're pleading guilty today?
No.
Has anybody promised you what I will sentence you to in this case?
No.
Do you understand I do not have to follow the sentencing recommendation of either the prosecutor or your lawyer?
Yes.
Have you had enough time to talk with Mr. Reardon before pleading guilty today?
Yes, I'm fine.
Has he discussed everything about your case and answered all of your questions?
Yes.
Are you satisfied with the advice he has given you?
Yes.
Have you been threatened or coerced in any way to plead? All right, Ms. Gretzky, if the case went to trial, what would the evidence show?
The evidence would show on January 7th of 2026 in Willoughby Hills, Lake County, Ohio, the defendant, Brandon Truitt, had a firearm on him. He had previously been convicted of assault as a felony of the 5th degree in case number CR 1964195A in Cuyahoga County Court of Common Pleas on March 31st, 2020. That conviction prevented him from legally owning or having the firearm.
All right, Mr. Reardon, anything to add to those facts?
No, Your Honor.
And Mr. Truitt, did you hear what Ms. Gretzky said, that the facts would show if the case went to trial?
Yes.
And are those facts true?
Yes.
All right, what is your plea to count 1, having weapon while under disability, a felony 3?
Guilty.
And what is your plea to the forfeiture specification?
Guilty.
Mr. Reardon?
Sign right there.
Handing the court back the written plea of guilty, witness the defendant and Mr. Attorney Stone will also sign the witness.
Mr. Truitt, is this your signature on the written plea of guilty?
Yes.
Did you sign it voluntarily?
Yes.
Do you want me to accept your written plea of guilty?
Yes.
Accept the written plea of guilty. The defendant was present. Mr. Reardon advised of all of his rights, made a knowing, intelligent, voluntary waiver. He understands the nature of the charge, consequence of his guilty plea, and the maximum penalty. Find him to be knowing, intelligent, voluntary. Will accept his plea of guilty and find him guilty of count 1, having weapons while under disability, of felony 3, and the forfeiture specification. I'll refer this for a pre-sentence report and a psychological evaluation. Sentencing will be June 10 at 8:15 a.m. and the bond is continued. Anything else, Ms. Gretzky?
No, Your Honor, thank you.
Mr. Reardon?
Yes, Your Honor, 2 things. No, I'm okay with the sentencing date. My client still has the ankle monitor on, the GPS. He's had that on for quite some time. I believe you're still living in the extended stay hotel that his mom's paying for. I don't know that we still need that, but I bring it up to see if the court would consider potentially removing that at this point.
Do you take medication right now?
I take a shot.
What do you take?
I don't know the name of it. I just know it's for my head.
All right, how often do you take it?
I think every 6 months.
And when does it due again?
I got it when I was locked up, when y'all had me in Lake County.
All right.
So,
All right, do you have a position on bond, Mrs. Gretzky?
Your Honor, there is a condition that he's not to have contact with the victim, which I presume in municipal court, with
Well,
the
who's
facts
the-
of stated, it would have been the brother, is my presumption. However, there's
it-
no charge that I'm aware of where he's actually charged
Okay.
as the victim.
All right.
So I have no objection to a modification. I don't know if that's the reason for the housing. I have no objection to a modification for the no contact with victim to be removed. The other conditions, that he shall not use or possess firearms, and must take medications as prescribed, I'd ask that remain.
Well, okay.
And then I defer to the court on GPS.
All right, I'm gonna reset the bond at 10,000 cash or surety, or 10%. In that you maintain medication compliance. I mean, it's already against the law for him to possess a weapon, so if he possessed another weapon, he would be arrested, and his bond would be revoked, and here we go again. So that's the condition, is you remain medication compliant. Anything else?
So that no GPS and there's no contact order.
I reset the bond
Yeah,
with one condition, medication compliance.
understood. Thank you, Your Honor.
All right, that's it.
Alrighty, friends. About 20 more minutes to go. If you're new here this morning and you have not already done so, please say good morning to us in the chat. Let us know you're here. Judging by the stats today, we've probably had a lot of new people. So introduce yourself. Like I've said before, we're a friendly folk. Let's go back up to Michigan, Otsego County. Judge Mertz, again, where justice is best served in a converted pole barn.
Yeah. Today. Yes, Your Honor, we do have an offer we intend to take advantage of today. It would contemplate a plea to count 1 and count 2 with a habitual second offender notice, dismissal of the habitual 4th offender notice, the controlled substance second offense notice, as well as count 3.
Mr. Rolla, is that a correct statement of the plea offer?
I believe it is, Judge.
Mr. Stats, is that the plea agreement that you've discussed with your attorney?
yes, sir.
And have you had an adequate amount of time to talk to him about that?
Yes,
Do you want to proceed with that plea agreement today?
yes,
Can you raise your right hand, please? Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth to help you God?
yes, sir.
Thank you. You can lower your hand. Mr. Spatz, are you currently on any kind of probation or parole?
No,
All right. And under this plea agreement, you would be pleading guilty to count 1 as a second habitual offender. Count 1 is possession of a firearm by a prohibited person. As a second habitual offender, the maximum possible penalty you could face for that charge would be up to 7 years. I'm sorry, 7.5 years and a $7,500 fine. Do you understand that?
yes,
And count 2, which is possession of cocaine as a second habitual offender, the maximum penalty for that would be up to 6 years. Do you understand that?
yes,
With those maximum possible penalties in mind, what is your plea to each of those charges today?
guilty,
Right now, you have certain rights. I'm going to go through those with you. You have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you, and the right to testify at a trial yourself if you wanted.
You understand all those rights?
Yes.
You understand that you're going to be giving up and waiving all of those rights by pleading guilty?
Yes.
Also, you don't have an automatic right to appeal the plea that you're making here today. You can only do that by leave, and that means that you would have to ask for the Court of Appeals to hear your case. If they said no, then that would be the end of any appeal. Do you understand that?
Yes.
Has anyone threatened you with anything to get you to plead guilty?
No.
Has anyone promised you anything other than what we've said here on the record today?
No.
Is it your own free choice to enter this plea?
Yes.
Are you pleading guilty to these two charges because you are actually guilty of these charges?
Yes.
The information I have indicates this happened back on August 30th of 2025. Is that the correct date?
No.
Okay. When do you believe that this happened?
February or January 3rd?
2026?
Yeah. Or yes.
Okay. Hold on one second.
And Your Honor, I would indicate that date is consistent with what's on the police report.
The January
The
date?
January 3rd date.
Okay. So, looks like the information is incorrect in the date. So on that date in January, were you present here within Otsego County?
Yes.
All right. And at the time that you were here in Otsego County, did you have possession of a firearm?
Yes.
And were you prohibited from carrying any firearms because you had a prior felony conviction?
Yeah.
Okay. Also at that time, did you have possession of some cocaine?
Yes.
Did you know that that's what that was?
Yeah.
Did you have any legal right to have any amount of cocaine at that time?
No.
Had you, and you indicated that you had been previously convicted of felony controlled substance offense. Is that correct?
Yes.
Mr. Rollard, the people satisfied with the factual basis?
Yes, Judge.
Mr. Trush?
Yes, defense is satisfied.
Counsel, are either of you aware of any threats, promises, or inducements other than what's been placed on the record?
I'm aware of none, Your Honor.
Are you both satisfied that the court has complied with statute and court rule in the taking of this plea?
Yes, Your Honor. Defense is satisfied.
Mr. Spatz, the court finds that your plea is knowing, voluntary, and accurate. The court is satisfied that there is a factual basis to support a finding that you are guilty of this charge. The court will accept, actually, both charges. The court will accept your guilty plea as to each. We'll set this matter for a sentencing hearing. Between now and then, somebody from the probation department will be in touch with you to prepare a pre-sentence report. You'll have an opportunity to go through that with Mr. Trush prior to the sentencing hearing. Mr. Rolla, anything further on this file we need to address?
No, Your Honor, thank you.
Mr. Trush.
Your Honor, there is a bond issue that I would ask court to consider.
Okay.
So the bond is presently set at 10,000 cash or surety. Mr. Spatz has another matter pending, and he can't start that matter until he's able to be released here. They have a hold on him, but they won't begin processing their case until he's there. I'd ask the court to consider modifying the bond. He doesn't have the ability to post $10,000. If the court were to even raise the bond up to a 20,000, 10%, he would be able to post that. He's not going to get released out into the community. He's going to be transported, but the other matter starting is going to allow him to serve the time concurrent. So I'd ask the court to consider that. I've been in contact with his attorney, so if we do need to make arrangements for him to be made available telephonically or via Zoom, we can do that. And we'd waive in-person sentencing to the extent that that was necessary if he is transported somewhere else and that has to happen. But we would prefer to be able to let him get the other matter rolling.
Okay, so he hasn't posted bond in the other matter? He has not posted bond?
He has not.
Okay.
They have a hold on him.
Okay. But he's not under sentence in this case. Yeah, obviously.
Correct. And as the court knows, if they don't come get him till after once he's sentenced here, it cuts off his potential credit anywhere else under People versus Gibbons. If he posts his bond hearing, it's transported there, we're probably still dealing with some small period of time, but at least we're reducing it.
Mr. Rolo.
Right, I was pleased to be entered in this car, in this case now, the people don't have an objection to that request, how the court chooses to amend by.
Okay, so Mr. Trush, based on the lack of any objection, I would modify it to the $20,000 10%. So I'll just ask that you prepare a stipulation on that and submit that to the court.
Just to be clear, does the court want a stipulation or just an order?
Sounds like Mr. Rolo's agreeing to it, so.
Either way, Judge, makes no difference. If it's an order, he can submit it to our office by email and get permission. If he does the other way, we'll do it that way as well. Makes no difference to people.
Okay, Mr. Spatz, do you have any questions about how we're going to proceed with your case?
No, Your Honor.
Where is the other matter at? What jurisdiction?
I'm not completely clear. I think it is.
In Michigan?
I think it's Indiana. It's going to come get him.
Oh, all right. So that raises another issue because I don't want to have to bring him back from Indiana.
Well, and that's why I said, well, I mean, we would waive in-person sentencing if that becomes necessary to facilitate that.
What are the guidelines in this case?
So on the low end, it's going to be 10. I think the high end is 28. So it's a situation where we're likely looking at either a long county jail sentence or a shorter MDOC sentence.
All right. I'm changing my mind. I'm not going to allow a modification of the bond, given that it's out of state. If he's transported to Indiana, I have no idea what's going to happen in that case. I don't want him to be released from in that case in custody in Indiana. And then how do we get him back to Michigan? That sounds like I'm not going to put our community in the state of Michigan in the position of having to go find Mr. Spatz and bring him back from Indiana for sentencing. So I'm not comfortable with allowing him to be released unless he can post the bond as it is. So I'm going to deny the request to modify the bond, given that extra information.
Understood.
So we'll proceed with sentencing. I'll get it on the docket as quickly as we can.
Understood.
Okay, Mr. Spatz, that's all for your hearing today. We're going to disconnect this time.
Okie dokie, friends. I got about 10 or so minutes to go. We'll go back up to Judge McNally, catch 1 or 2 hearings from him to finish off the day.
Did he come in the wrong day here? You're supposed to be here tomorrow.
He's on the docket today for prosecutor review.
Well, this is a Woodhaven case. Is Woodhaven here today? They are, aren't they? But I also have a show cause schedule.
For tomorrow, yes, didn't realize that his prosecutor review was scheduled a while back when I had a sentencing for today, and then we scheduled a show cause hearing for
It's fine.
tomorrow.
Go ahead. I'm going to go ahead and arraign you now. The charge is that you failed to attend and complete the anger management program. That is the charge. You have 2 prior technical violations. If you plead guilty, your special status under HIDA could be revoked, the conviction entered, and you can be subject to a 90-day jail term. You understand that?
Can I have a question?
Sure.
Can you kind of explain that to me a little bit?
Yeah.
Thank you.
Yeah, I'll be glad to. And then I'll give you a lawyer. They say that you failed to attend and complete the anger management program with 8-week follow-up. That's what they're telling me on this show cause. If you plead guilty to that, or if you are found guilty, your HIDA status could be revoked. The conviction entered, and you'd be subject to a 93-day jail term on this assault or assault and battery charge. Do you understand that? You are presumed innocent. They have to prove you guilty by a preponderance of the evidence. And when I say presumed innocent, I'm talking about on the show cause violation. If you plead guilty, this would be your third technical violation. You have 2 priors. So that means you could get 15 days on this. Do you understand that?
Okay, I'm just gonna be completely honest with you. I did mess.
I don't want you to say any of that yet.
I was gonna say, give me gas. I have no money. I can't do nothing. I'm falling out of bad. I was trying to go to the army, but I can't because I'm on probation. I can't do nothing.
Let's just slow it down. Will you slow down with me, please? They have to prove you guilty by preponderance of the evidence. You have the right to question their witnesses, to bring in your own, to use the subpoena powers of the court to bring in those witnesses. If you plead guilty, you'll be giving up all those rights. And we're not going to have a hearing. Do you understand that? You have the right to a lawyer. We're going to give you a lawyer. We're going to get you a lawyer right now. In fact, since Woodhaven is here tomorrow, I think I'm going to handle this tomorrow, Heather. Right? Woodhaven's here.
They're not here tomorrow, Judge. They're just here on Wednesdays today.
One of these days, I'm going to figure out when these guys are all here. I got it. Okay. Who's our probation lawyer today? John?
Who's Teal?
She's backed up though, isn't she?
She is.
And Judge, we have a well, no, I'm sorry. Forget what I was gonna say.
Well, tell me. I mean,
No, I was gonna say we have an interpreter case, but they have a retained attorney.
well, then let's do that.
Is there somebody in the docket name for Eric?
You want me to go ahead and put that attorney? They're all on right now, but do you want me to put her in with the prosecutor to meet with real quick before we start that one?
Yeah, you can do that. Absolutely.
Okay. I will do that.
Trying to figure out how I'm gonna do this with you. I don't want you having to wait around here all day.
Done everything else. I know you said done like 4 or 5 classes and then I didn't pay.
We're supposed to do 8-week follow-up though. Why did you do that? I wouldn't have, I only order things I think are necessary. I'm not trying to burden people unnecessarily. You needed to do that. Where do you live now?
It took me hour.
Hour? What was there? An accident or something?
No, it's traffic, but it's normally like 45-minute drive. It's hard for me. I'm trying to do the right thing. I want to go to the army. I want to start a life. It's just held back by some of those things I didn't pass.
All right, slow down. Yeah, you're gonna put them in a breakout room, right, Heather?
Yeah, I'll go ahead and get them all in a breakout room until she comes out.
And then the important thing about the no contact.
It's not my Woodhaven docket today, though. It's Judge Hessen's, right?
The interpreter case is ours.
No.
Judge Heston has Woodhaven.
Judge Hessen is
Oh,
Woodhaven
yeah, I'm
today.
sorry.
Like they finally lightened up back in your
The
class.
probation officer, Ms. Wild, she's not here today.
No, Jessica's the only one here today.
Call in Jessica. Yeah, you go ahead and put them in a breakout room, whatever you have to do, Heather, okay?
Okay,
Thank you.
the attorney's meeting with,
You want to go in the army?
Carter.
I want to change my life. There's nothing in Michigan.
It's not what?
There's nothing in Michigan but dead ends.
Why do you say that?
Every time I get a job, it'll go good for a couple weeks and then it gets slow, or then I'll cut my hours, or my family's terrible. It's just a whole bunch of bullcrap. Taking care of my little sister, just a whole bunch of.
How old is she?
She's just turned 8.
Are you living with your parents?
Living with her for shit. My little sister stay there and ready for it.
Where's your parents?
My mom. It's in jail. So it's not me. I want to change.
So he tells me he's gone to 3 or 4 weeks of anger management.
So taking a look at it, this is Ms. Wild's file, so I take a look at it, it looks like he attended 2 of the so he attended the intake and then he attended 2 of the follow-up sessions on March 24th and March 31st. However, he had not returned since. He was registered for both the April 7th and the April 14th, but unfortunately missed both of those as well as the session on the 21st of April.
Let me see the screening report or PSI. Why didn't you go to those?
They were on Tuesdays, right? Yeah, I had work. Was working at KFC. I want to take 30-minute breaks. I didn't want to decorate my job.
Why aren't you still working at KFC?
They cut my hours. Like 21 or 22.
Let me see the police report, please. Who was your fight with?
Philip Brady, I think was his last name. One of my best friends.
Hang on. Boy, nice language you used on that day, huh? Well, I mean, I'm talking about racist comments. You know what I'm saying? You're a racist? Why'd you use?
I didn't say the ER or nothing. I'm not racist. I was having a fight. You know, I was upset. I was at my own house. They came there, so I was upset. I just should have controlled my mouth. Now I know to walk away or not come outside.
He's done everything else?
It looks like he's completed everything else. The only thing that was ordered was court work program dates, which looks like those are done. I'm not sure if his balance is up to date or not. She didn't include it in the violations, but I assume it's either up to date or.
Pay all your fines? Amy? I want you to note on this file what's going on. I've arraigned him on the show cause. He wants to go in the Army. Hang on. He wants to go in the Army. I want you to note what he's done and not done on there, Amy. And you can say, Judge McNally, we're going to give this to the prosecutor, Woodhaven. And if he still wants to move to dismiss, so you're going to write that down. He told Judge McNally he's going in the Army. Defendant's done everything else other than completed more than 2 follow-up sessions of anger management. He did not complete the rest. I ordered 8-week follow-up, but he wants to go in the Army, and I have no problem if the prosecutor wants to move to dismiss this. Even though you don't talk like that, son.
I'm sorry.
You know that? I think it's so bad when we have racist people in this country. You don't talk like that. You don't talk like that. I don't understand why anybody thinks they're any better than anybody else. I don't care what color they are. I don't care what man. Just disgust me. So before I change my mind, go out in the hallway. Go and take that file to the prosecutor after she makes up that. Will you please, Amy?
Yes, sir.
Thank you. Burgor.
And before he changes his mind, we're going to go ahead and end our day because you know as well as I do that once we log off here at TCF, all court around the country just stops. So that's the best bet for that defendant to get through this. Anywho, hope y'all had fun today. I did. We will be back this evening, 7 p.m. Eastern, 4 p.m. Pacific for In the Blind with Mike and Dan. You can find me over there. Just hang tight. As soon as I log off of the stream, YouTube will send you over there so you can subscribe to that channel if you're not already. You can set your notification, all that good stuff. If you're not familiar with In the Blind with Mike and Dan, and you might not be because you're new here, it's a totally different show. It is not court, but the shtick there is we have no idea what we're going to talk about until it is presented to us in real time. So it's good fun. So check that out. But over here, we'll be back tomorrow morning, 9 a.m. Eastern, 6 a.m. Pacific. So I hope to see you then. In the meantime, have a great day. Take care. God bless.